All right, welcome everybody to the Planning Board special meeting for, no, it's not a special meeting, excuse me, to the Planning Board meeting for UDO update continuation. Seeing we have a quorum, we'll call the meeting to order with the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all. Thank you. As we start off each planning board meeting, I'm going to read a statement. Does any member of the planning board have a conflict of interest or the appearance of a conflict of interest with regard to any item on the agenda? And if so, please state so at this time. Sybil?
No, I do not.
No, I do not.
And I do not.
I do not.
I do not either.
Okay, seeing that no one does, we have a draft agenda before us. And before we entertain a motion to accept it, I'd like to add an item to this, and we'll do it right before public comments. Would that be the proper place to put it? It would have to do with a brief discussion regarding scheduling of some upcoming planning board meetings. And I'll put that in as, well, right before public comments, which I guess would be...
So it becomes 5 and public comment 6,
yeah,
7.
exactly. That'd be 3, and then it drops down to 4, 5, 6, and 7. All right, the amendment I'd like to add to this is to discuss a couple upcoming planning board meetings, just to make sure that our schedules are in line, and to hear from Chad as to some other people that would be involved in those meetings. Can I have a second for that motion?
I'll second.
All in favor?
Aye.
I want to thank the chair for inserting this in the agenda.
Okay.
I do have one additional suggestion for the agenda. We had discussed previously that we were going to spend some time at this meeting specifically discussing some of our learnings from the conditional rezoning application and whether or not there are certain amendments that need to be made to the UDO now that we've had a little experience. We had kind of an informal discussion at the end of the last meeting that I thought was fruitful, but we've kind of discussed putting this on the agenda at some point, and whether it's a discussion that focuses on text amendment to the existing UDO over this subject, or whether that's something that can be done in the revised draft that we received. But I'd like to see that either specifically on the agenda today or specifically scheduled as an agenda item in the future.
In addressing that, Richard, the email that Chad, our planning director, sent out to all of us, dated the 16th of May, he indicated that we will be receiving a complete draft, and Wes has just indicated that we may get it in sections, but that we'll be receiving a complete draft of the newly formatted UDO so we can take a look at it at this revised language, and then we will have time prior to, probably in the next 3 meetings that we would have, to address the conditional zoning as we come to it.
Okay.
Would that satisfy your...
That's sufficient.
Mr. Chair, if it helps, it's in Article 2, so you'll actually receive that today. I think Wes did say you had Article 1 and Article 2.
Yeah, that's
Is that clear?
And the additional, and Wes, you confirmed this at the last meeting, you're also going to provide the revised telecommunications language that inserts the 100% coverage as a...
That was not agreed on by the board. That was something that I think we were going to discuss further, because that was something that you were interested in.
Yeah.
The rest of the board was not in agreement, so there wasn't consensus.
We can discuss that when we come to that
get there.
telecommunications chapter. You'll have an opportunity again to bring up and state and make your case.
Yep.
Well, my understanding was that, and if I'm in error, time to correct me is now, is that you were going to provide a draft that included language that simply includes as a topic of consideration within the regularization the carrier's inability to provide 100% coverage.
I need to go back and look at the minutes. My understanding that I was and I think the time to talk about this is when you get the revised material. But my understanding, I was tasked with reducing some of the ancillary criteria that seemed to be a bit burdensome.
We were
and
going to
taking
remove
that out,
several items.
and then specifying certain types of towers, like whether guy wires and those types of things. But that criteria will need to be discussed further.
All right, we didn't revise the agenda to include that,
Yeah.
but we'll let that discussion go because I know it's important to certain members.
Okay.
I'd like to move on to public comments on agenda items only, and today we're talking about updating the UDO. I see we have people in attendance. Would you like to make any public comments? Okay, well, thank you for attending. Thank you for showing direct interest here. We're now going to move on to item number 5, which is UDO update continuation. And just for the edification of those watching us on YouTube, today we resume our UDO update process. And I'm optimistic that we can today complete the phase 2 process, because the only remaining item is Article 7, which is definitions. And that would conclude Part 2. And then, as Wes has shared with us off camera, he has 2 of the sections, 2 of the articles ready to hand over to us today for our, we'll call it a phase 3 review. And then he'll, in the next week or so, be able to give us the remainder, hopefully.
Yes.
So we'll have that complete package in a binder that we can start from page 1 and start reviewing through to make sure that for the 3rd time that we're satisfied with the new wording, the new revisions. Chad, do you want to start us off with definitions? Do you have anything to add to that, or?
The only thing I will say is that Wes can correct me if I'm wrong, is that we'll go through definitions today. 50% to 2/3 of these you've already reviewed in past articles. Is that correct?
That's correct.
So there's only a few, maybe a third of these that you haven't seen before. So that should be yes.
I would say a number of them have been missed.
Yes, I agree.
And so there may
So-
be, and so what I was to
And we'll deal with that
Mr.
today.
LeBruno's point, there's a couple of them that I know need further revision after I was starting my 3rd phase review, like automotive in particular, I noticed. So, yes, let's go
Okay.
through, figure out what we've missed, and then I'll be prepared.
Before we
to
leap
change.
into that, I'd like Chad to address the item that we discussed, which has to do with schedule. Right now, our next, or do you want to do it at the end of the meeting?
I want to do it when we moved 5 to 6 and created a space in between. I think that'd be the proper time to address
Okay.
upcoming articles and
Okay.
meetings.
One of the things I'd like to comment on
Mr.
is
Chair.
I'm sorry, Jerry.
No.
Go.
Wes, why don't you review first what you have found in this definitions that you would...
I'd like to add something before we get into the meat of the Article 7 definitions,
Okay.
if I could, please.
Yes, sir.
Just, I guess, some housekeeping. Today, we're here to review definitions, Article 7. We are not here to, because we have, in our Phase 3, we have the opportunity to regurgitate background on the various topics. So right now, we have definitions, which gives us a word and then a couple of sentences, including a definition. And that's what we're here to discuss, because that is what Article 7 is. So I'd like us all to, including me, to resist the temptation to look beyond just the wording in a definition and get into discussions that involve those topics, because Phase 3 is really the time for that. And when we look at that draft package that Wes is going to hand over to us. All right, Jerry, please.
Yeah, not to expedite the meeting, but I'd like to hear from Wes what changes he would make to this document or
To the definitions?
To the definition.
So
Okay.
I know that
Does anybody,
I prefer just going page by page. And when it comes up, he can just say he's already knows
Okay,
about
that's fair
that.
enough. That's fair enough.
Because they're all like spread out all over the place.
Yeah.
Yeah.
I'm set up to do it in alphabetical
Let's do
order,
it.
just as the
Yeah.
document
Let's go for it.
we have in front of us.
Okay.
On the very first
Before we get-
page.
I'm
Go ahead.
sorry, Pete.
Go ahead.
I wanted to confirm and state my agreement in terms of, let's keep our eyes on the page here. But I think for the public record, phase 3 is when this starts to become cement. And for those of you out there that are listening that are concerned about how this is going to impact the future of Sunset Beach, now's the time. And absent public comments prior to the final revision, this is what we're going to be living under for the next 5 to 10 years. So it's
Well,
very important.
there's some truth in that, Richard. However, the town council is the one that has the authority to
Fine.
accept or reject or revise.
Yep.
And hopefully they're the ones that are watching and been paying attention for the last
And
16
that's when
months.
it becomes cement.
Yes, exactly.
Thank you.
Sybil, did you have anything to add at this point here?
No, I'm just ready to get going.
All right,
Let's
on the,
go.
on the first page, we have buildings under rules of measurement. We have building setback lines, but there is in the body of it, building setback lines, so it's a repeat. I think it should be taken out of one place or the other.
Okay.
And I have some suggestions on that definition, but I'll wait until we get to the building setback within the body. Lot depth under rules of measurement on the page 7-1. It talks about the midpoint of the front line to the rear of the lot. In a strange configuration for lot, which we have, just going to the center of the lot or the midpoint of the lot and then measuring that depth is really not accurate. I would contend that it's the average depth from front to back across the lot. Now, we used to have a sketch in our old definitions that showed that, but it showed a trapezoid, which it would be accurate. But if you had something that was a strange configuration in the front or the back, the midpoint is not going to give you the average lot depth.
We can, yes. See.
Now, I guess, Wes, consider that.
Yep.
Consider that. Because you're going to be coming back to us now
Sure.
with these definitions after today.
Okay.
All right, does anybody have anything else on page 7-1?
No.
Nope.
On page 7-2,
On lot of
Ron?
record, you have just a spelling error. It's not meets, it's METES.
you
Not
mean,
M-
you mean
not
that's-
MEETS. It's meets and bounds.
Yep.
Which is also a straight line, by the way.
Mhm.
Yep.
Courtesy to French or somebody, I forget who gave us that. English.
I liked it before where we had sketches, but I think the
I-
sketches can be kind of cumbersome too. But
Let me see about adding those back in.
okay, because under lot width, I really would like to see a sketch.
Okay.
Because similarly, it may be a cartoon, but I think it makes it
Okay.
easier for applicants to understand what dimensions they're dealing with.
Got
And
it.
particularly with lot width, we have a number of different zoning districts where it's a percentage of the average lot, or of the lot width.
Yep.
So it's key to know what that definition is. Under setback front, this is still on page 7-2, we have a setback across the full, it should be front width of the lot. I think the word front should be inserted into that. Because this is a front setback. And that setback is across the full front of the lot. Now, I can understand why the word width was put in there, and maybe you might determine that that's a better legal description. I'd just like you to consider that.
Yeah, I mean, front can go in there. I think it's understood, but front can go in there. It doesn't hurt anything.
Under rear setback, the next term, I also would contend it's full rear width. which is the same description or the same question. Does anybody have anything else on 7-2 page?
Other than a general question, Wes, when you get to the bottom, word interpretation, when you're saying that when things are not defined, it's not necessary to, I mean, you're giving it to the UDO administrator, but I noticed we don't like specify the dictionary.
Yeah.
I thought I've seen in other documents where if a word's not defined here, then it's the American Heritage 2020 version dictionary is the official dictionary of the town. Is that worthwhile putting in?
So I mean, the reason the UDO administrator can always take that into account, but contextually, it is better for the purposes of administering this for staff to utilize. There may be a word in the dictionary that can be used out of context within the development framework, and so the onus is on staff for interpretation. And it's been my opinion that over the years, sometimes the dictionary definition can be brought in if it's ever appealed to the Board of Adjustment. But I think it's first important for the person that's in charge with it administering this, for them to tell us what that word is, and for them to be able to use professionally accepted sources. And that may not necessarily be
Webster's dictionary. And I agree with Ron, though, that there's a little confusion on my part, because I think it should say term used in the ordinance is not defined herein, because if it's not defined, well, somebody could bring Webster's dictionary and say, here is the definition, defined herein, because we're dealing with our UDO here.
Okay. Defined herein.
Yeah, defined herein. Then the UDO administrator can interpret.
And is professionally accepted sources a little broad, or is that?
So, I mean, I think if it would be useful, we can say such sources may include, American Planning Association or engineering manuals or things of that nature, in addition to the use of Webster's dictionary where necessary. Would that be helpful?
Well, I'm just trying to decide what's the better. I mean, obviously, the way this is sort of written, it gives more kind of administrator's discretion to pick. But then I guess I'm looking, if you get into a dispute, now we're going to get a battle of books.
Well, it goes to the Board of
Somebody's going to say, my book says it means this, and is there any way to avoid that, or that's just the way it's going to work?
That's
the way it's going to work.
That's the way it's going to work. But
Right.
if you specifically just call out only the dictionary,
Right.
then it hamstrings staff on and potentially the Board of Adjustment as well.
Well, I'd like the UDO administrator to be able to justify it, and I
Yeah.
think that that's appropriate. He's the professional that should have the best, the deepest interpretation of what we're talking about.
Correct.
Well, would it be helpful to have language that says the term in accordance with professionally accepted sources, such including but not limited to, and then list?
I can list it.
Because then at least you get kind of an umbrella of, because I mean, professionally accepted sources, I can run with that.
Yeah, I mean, is Wikipedia that? Somebody
Yeah.
is good. That's when you kind of want to get it
and
down to
that's
something.
and that's where I
Right.
kind
Can't
of like
Google
the way
it.
that's why I kind of like the way it's left is now.
I
It
agree.
ultimately comes down to me making the decision. If they're not happy with it, they have the
They've got recourse,
Yep.
Yeah.
Yes.
Yeah, that's
Okay.
right. So
And
just leave it as
and
is.
it's recourse in the town level here
That's
too.
right.
So it's
Yeah.
All right.
moving on. I'm on page 7.3 under accessory structures. I thought we had talked about having no living, sleeping, eating, cooking, sanitation, maybe not sanitation, because otherwise it's an apartment by a definition.
so
And I know you've struggled with this.
so
Wait a minute.
you're talking about
You've gone
accessory
down to
structure.
accessory?
Yes, accessory. It's on the.
I had something before that.
Oh, I'm sorry. Sorry. Let's stay in order then.
On L, on page 7.3, could you read that and explain it to me? I read it several times and I find it confusing.
The word itself includes. We're talking about the word includes.
The word includes, yes. Shall not. The word includes shall not. Okay.
It's actually talking about the word includes.
Okay.
Yep.
Could that be put in
Quotes?
Yeah, I was going to suggest putting it in quotes.
Because I kept going, wait a minute, includes, that's the wrong verb. No. Okay.
Yep.
that okay?
I can try
I got
to
it
add
now.
all these.
Yeah.
All right, sorry. I'm going to move on to the bottom of page 7.3 unless somebody has something sooner than that.
They're hard. Yeah, I agree with you. It's a little hard because we first got to figure out that the sentence is talking about the word includes or the word street. So
Yeah,
maybe if you put quotes or
I'll put-
around those,
yeah.
then it
Yeah.
helps. It's helpful.
The word
So-
structure,
Right.
the word lot.
Right.
Yeah.
Okay.
So, Mr. Chair,
Yes.
I don't know if I've really struggled with it, but we as governmental bodies struggle with completely prohibiting this. There is a sentence in our UDO now, it will continue to be in the new one, that says these structures cannot be used for financial gain to
Yes.
some degree. But if any one of you or anybody else would like to come an accessory structure on your property, as long as it meets the setbacks, you're allowed to do that. If you wanted to put a bathroom in it and run those facilities
That's
too,
why I took sanitation out of it.
yeah,
It's-
you can do that. If you wanted to put a sink in there, if you wanted to put a
Kitchen?
kitchen, well, and that's, I'm getting ready to get to that one. If you wanted
Okay.
to put electricity in there, I can't stop you from
I'm
wiring
not
it.
saying to stop
But
that.
when it comes down to the being a full-blown living quarters, the kitchen is what makes it key here, is that you don't have a full kitchen in there, so therefore you can't have a range. In my experience, that's how I've always defined it. You cannot have a stovetop in there. You can have, who says you can't have a refrigerator in your outdoor working space? Those things. So a full size.
I'm talking about living, sleeping accommodations.
So right, but the difference has been is the range here, the stove, that makes it two separate independent living facilities.
So you're saying we can't do this?
So,
What I'm asking.
And Wes can help me here.
so you do have accessory dwelling unit now defined in your ordinance, and the only places that those are permitted are what we determined, which is MB2 and BB1. So if it was uncovered that someone
For commercial.
that's right. And so if someone tried to convert their accessory structure into a habitable space,
Mhm.
they'd be in violation of the ordinance.
I just don't see where it prevents them from having a habitable space in the residential section by this definition. So
I mean, it gets into the whole thing. You've got to be able to prove with.
all right, if you say that we can't enforce it, or it
becomes one of those things where if somebody does it without my knowledge and I get a complaint on it, it becomes one of those things where I have to figure out.
You
how
can't put
to-
in there that it's not an apartment dwelling unit.
What-
An accessory structure is what we say there and is not an apartment dwelling unit.
Well, I mean, by virtue of the same thing that one use is certain thing, just different from
That
from
does it
another
enough
use.
that way.
That's right, because it would say that if you're going to have an accessory dwelling, it can only be MB2 and BB1, and by the way, it can't even be detached. It has to be part of the principal structure under roof. So if someone tried to convert a garage into a rental unit, that'd be a no-no.
well, that's a financial gain.
Well, but it's also would be defined as an accessory dwelling unit, and it would be a violation of the terms of the ordinance. They wouldn't.
Well, the garage would have to be detached. Yes. Okay.
It would. So if you look, I mean, we can go back, but if you look at accessory dwelling unit, remember there's a use now on the table that specifically defines that, and there's supplemental regulations also that call it out.
So what you're saying is there are regulations inherent in the UDO that satisfy what we're trying to accomplish in this definition?
Correct.
Pete, are you happy with that or no?
I'm not, but I guess I can't have my cake and eat it too. Because continuing on with the same definition, we've added a couple of sentences or a sentence at the end here. And what we were trying to do under accessory structure is we were trying to deal with somebody who wanted to put an addition on their house and connect it with a 5-foot wide a covered roof system.
Mm-hmm.
I think it's the wrong place for this. I think that needs to go under building principle, because it's showing somebody how they can expand their building, their principal building, without
Triggering an accessory structure.
without triggering an accessory structure. Yes, but also whether that wording is here or under building principle, I think it serves the same purpose. But I would like to see that it's not just 5-foot covered roof system, that it is framed and enclosed from weather. Because somebody can put a 5-foot awning going out to something that's 10 feet, 20 feet away from their house and go up 35 feet with it.
Does
And it
that-
would be connected to their principal structure, so it would fall, including setbacks, it would fall under principal structure.
does
And
that
I'd
get
hate to see
into-
people doing that with a detached garage and going up 35 feet, where right now they can only be 16 feet.
Does that get into the design criteria of something to where we can't really regulate that?
No, I think it's fine to specify that.
But again, I like the 5 feet as it's worded, but and framed and enclosed from weather.
Conventionally framed and covered roof system and fully enclosed with a minimum width of 5 feet.
That does it.
Now, would that include a causeway that is simply sheltered? In other words, a roof?
No, it has to be
Fully
enclosed. It has to go all the way to the ground,
Got it. All right.
and it has to be enclosed. That's
All right.
period. And I didn't want it just screened. I wanted it enclosed from the weather. But
Good point.
I'll take the half a loaf. All right. Does anybody have anything on 7-4?
Yeah. Two things, one minor. On adjacent property, we go, and this maybe is the way it is already, define for residential districts as any adjoining lots. But we don't define adjoining, we assign the word abutting.
Sharing.
Should we be, I mean, what the first definition is an abutting lot, right? It's the first one. We don't define adjoining. I just wonder, are we just being kind of confusing there, that we define abutting, and I think we don't use abutting anywhere else. We start using adjacent and adjoining everywhere else.
I don't see a button.
First line of adjacent property.
Oh,
And it has the word adjoining lot.
but we don't define an
Page
adjoining
7-4.
lot. We do define abutting, which means having a property or or district lines in
What do you want
common.
to change it to abutting?
I don't, well, or, I mean, I think like in most other places, we keep saying adjacent or adjoining.
Well, can we include in that the abutting
So-
definition also can be inferred to also extend to and
Adjoining.
include those two terms as synonymous with abutting?
Because it says defined for residential districts as any adjoining lot sharing a common boundary. So is that the same as abutting? Because having a property or a district lines in common?
So abutting, and we can in fact we can update the definition of abutting to include the
Adjoining?
statutory definition that also which would be valid. If I recall, I need to look up the statute, but I think for notification purposes, I don't have it in front of me. I have to look it up.
Well, I guess the question is there any definitional difference between abutting and adjoining?
So abutting is used in the statute for notification procedures. In the North Carolina general statutes, not your definitions, that says that you're still abutting for notification purposes. I was getting ready to look it up specifically. Even if you're across the street, so you get noticed if you're across the street. If
So
you're
abut-
separated by a transportation.
Across the street is abutting.
But that's just for notification purposes. So it's different than, for example, if you're abutting for the purposes of determining what your buffer is. Does that make sense? Because you're not going to buffer across the street. You're only
Yes.
buffer when you share a property line.
And that came into play in our conditional zoning qualification for the 1 acre too.
Sure. So how about let me see if I can take a look at this, and I'll go through and do a word search on adjacent and adjoining, and see when I bring this back to you that it makes sense, and we may need to have just a carve out that says, for the purposes of notification, abutting shall also mean
Right.
X, Y, Z,
Or add the other definition.
or add the other definition.
Right.
Okay, right. In that point too, right before Ron's adjacent property, we took out the word addition. Is it because doesn't matter? We used to have a definition for addition to an existing building.
That's accessory.
We took it out.
That is, so there's a number of terms that are specific to the flood damage prevention ordinance that were moved into there.
Okay.
And
All right.
addition
It's in
was
the
one
other
of them.
section.
Okay. All right.
But-
I'll buy that.
My next set of comments is larger. Under adult establishment,
Why
I
did-
thought,
Did you cheat off my test here?
I thought, and I reviewed them in looking at the minutes,
I
that
know.
we had decided
Yes, and I'm prepared to
Okay.
talk about this.
that we had decided just to adopt the NC state standards, which is that 14202 Part 1, which comes from 160D-902.
You did. And so the reason why it goes further is because that definition is not broad enough, in my opinion. And so I have said clearly here that it includes all the things in the statutory definition, in addition to all these other things. And so from my,
But A, B, and C is in the state definition.
it is not specifically worded that way. It's different. I just reviewed this. We can go back through it again, but it
Yeah.
is different. This is a catch-all, and and it's similar to my comment before. We can defer to this, but it is, from my perspective, the town is in a safer position by having a broader definition to capture anything that would come into play here.
Well, and I also have an issue with A where it says substantial, because that's difficult to quantify what substantial is. I changed the word to significant, but I don't even like that word.
No, that's why I kind of thought, I got to find a meeting now, unfortunately.
I like it to say something like more than a passing or infrequent. You looking back at your margin notes?
No,
No, I know. Ron is exactly right. That's what was determined in the meeting, and I went back and reviewed it again and looked at the definition and felt like we needed to have some additional criteria here to make sure that we're capturing every possible circumstance. That's
Covering all
why.
the
That's
bases.
why it was in there.
Well, I guess, well, I need to find
I'm
it.
pulling the definition up right now.
Because I pulled the page from the state, and I thought their definitions were pretty substantial, and I guess I didn't really want to. Crap, can't find it now. Because yeah, so it's that 14-202.10, and it has definition of adult bookstore, adult establishment, adult live entertainment,
Yep.
adult live entertainment business, adult motion picture theater, adult mini motion picture. So it has more definitions than we have.
But this encompasses all of those things, plus the additional things that are not in there that have been added.
You've
Which-
combined it under entertainment as opposed to all the other.
That's
things.
right. Making sure we're clarifying what massage is included here, tavern as well. So there's other things in here that go beyond that. And look, I'm not going to die on this
Right,
sword, so
no.
I'm happy to strike it all and just call it that. But as your person
Do you
consultant that you've
object to the way
hired,
it's written now?
Well, I just think when in this particular subject, when I guess my inclination is to take the state and put it on them to define these things instead of us getting into it. I don't have any objections to D or E in this list, which is kind of like an exception. I don't know. I guess we hope it, because it occurs later then again too. I think in the S section, when you get the S's.
yes, there's
Right.
certain terms that have to be further defined,
Right.
and that's probably specified anatomical areas. Also
Right.
has to be defined.
Well,
Because those are already, to me, defined on the state list, but, okay. I just, I'd rather have this, yeah, it's
Go ahead.
under specified anatomical area, specified sexual activities, I was trying not to read them off. That since they're already defined by the state, that we leave it to them to create the definitions and not us, but,
Would his simple solution work, Wes?
I'm fine. We can just strike the rest of it. Retail or service establishment as defined as NCGS 14-20210 period, and we'll take the rest of it out.
My concern would be, it's been a
What?
while since I read the North Carolina statute, but my recollection is there was not, in my view, a sufficient carve out for what you cover in item E. And we do have establishments within Sunset Beach that provide services, massages, acupuncture that could fall under a broad interpretation of adult entertainment that we don't want to punish.
That's correct.
But
So
we deal with that, though. We deal with that in
There's
other
personal
sections.
service establishment,
Talk about
but this-
licensed.
Well, what is wrong with the way this is written? What is it that's
Because
wrong?
it-
Because it isn't your words?
It's not my words. I'm saying the state has words already. The state of North Carolina has already these definitions.
And they're specifically already called out and defined
Okay. Well,
by,
whatever.
by the first
But if there's a
sentence.
conflict, which wins?
Well, so you have your own authority to enact
Over your
rules
account.
and regulations and ordinances.
Okay.
The intent of this is to make sure that this is
They cover it.
taking into account everything, and then clarifying in instances that this doesn't come into play. I mean, this hasn't been an issue here forever.
Probably
so
won't be.
the fact that we're breathing hot air over this is frankly a waste of time.
If you'll agree to do it with the North Carolina wording,
Mhm.
why don't we just go that way?
That's fine. But to Richard's point,
I
that's
think
fine.
I think licensed massage
Yep,
are
that's fine.
dealt
Let's just
with in
take-
other parts
I am
to
fine.
justify that, other parts of our UDO.
are we,
it's just gonna all it's gonna say is retail or service establishments as defined per the statutory definition. Period.
okay. So I guess as we go through this, I just want to make sure that, as Pete suggested, that carve out exists in other areas, and we don't have to do it now,
Sure.
but I just want to make sure that it doesn't
It does
slip through the
under
cracks.
uses,
That's a dumb thing.
commercial uses, I believe.
Yeah, but if we get in a situation where a North Carolina statute seems to prohibit, does permitted uses
They
take?
can call Ron.
Huh?
Well, leave it in if you want to leave it all in. I guess my question is if we're saying that the statute,
Well,
it
there's
says the first line and then we,
There's a definition for a massage and a definition for massage business.
That's fine. I think
And it
let's
talks
move
about
on.
licensed physicians, licensed.
Yeah, let's move on.
I guess to me, it's
You
got to
beat
be
me.
one way or the other, but you can leave it, I mean, we either take the state definitions or we write our own. But
But you think it's too
But
much?
we're saying we're taking the state definitions and then we start writing our own. If we want to write our own, just write our own and take the state part out.
Well, this is it.
I mean,
It
I
is the
guess-
Sunset Beach UDO.
Right.
I had written our own before, and then we added the statutory definition, and then I felt like it was not enough, so it wasn't.
So just
and-
leave
and
it the way
so-
it
And
is.
so I rewrote it the way that it is there now, but I'm just asking for the what the board wants to do, because I don't care.
I think either way, we're
Yeah.
we're satisfying the issue at hand.
I
So
prefer this because it's very specific. I can look for all the words I need. I have no problem with it.
Yeah, and I like the fact that it is reiterated in the UDO. And I don't think, to Ron's point, I don't think it creates any conflicts. And this is an area where we want to make sure that the community is assured that none of these activities are going to one day intrude upon Sunset Beach.
maybe
we-
to
can we-
spice up
can we
things
go-
here a little bit.
Can we go past this now?
So are we leaving it as is,
We're
or
gonna leave it
we're
as
just
is.
going to leave? Okay.
Thank you.
Right? Does everybody agree? So
Yes.
we're
I'm
clear?
fine with
We're
it.
going to leave it as is.
Thank you.
Ron?
Sure.
Okay. Going on to page 7.5, I have something in the middle of the page that has to do with the definition agriculture. I thought we were going to try to provide a definition for agriculture, forestry. We do have a
don't have it.
livestock definition.
Where you at?
Where? I don't have it.
No, he's saying.
What page you on?
7-5.
That's where
I'm
I am.
sorry. I'm sorry. I misspoke.
It's
Right
not-
in the middle, right above air support, in alphabetical order, I said, didn't we need a definition for agriculture?
Oh, I thought it's on bona fide
We-
farm,
we-
is
we-
it?
Yes. Ron's right. So we had this definition that, and this discussion that we needed to defer to bona fide farm because we didn't want agriculture in the corporate.
Okay.
It might be
okay,
under
I
farm.
missed that.
Is
I
it
missed
under
that.
the F's, farm bona
Yeah,
fide?
yeah,
It's on the next page.
yeah,
Oh.
I missed that.
Yeah.
That's
Okay.
my error. Anybody have anything else on
Yeah, I just
7-5?
wanted to talk about air-supported structure. Does this include the temporary air-supported structures that are sometime provided at parties?
Fun house?
Beg your pardon?
A fun house?
Funhouse?
No, because
No.
they talk about them being, air is maintaining to support it of the structure where the access is via an airlock, and there is no airlock in a fun house.
Funhouse. Is that dealt with somewhere else?
That would be a temporary thing, right?
But we,
Yeah.
yeah, we didn't want somebody having accessory structure that was inflatable. I think that was our point.
Yeah, that's like Jerry putting a golf dome in his backyard, a golf driving range
Good
dome in his
idea.
backyard.
Thank you.
Okay.
Is what this referred to, right? It's like the golf driving range domes.
But,
In
but
a-
we weren't trying to address temporary fun
But not
houses at a
temporary
birthday
fun
party
houses.
in my backyard.
No.
Okay.
Okay.
Does that satisfy you?
Yeah, yeah, yeah.
Richard? All right, we go on to 7-6.
well, why
Whoops.
is applicant there?
That needs to be updated.
I know
noticed
because
that.
it's like part of the stormwater, but
That's right.
isn't an applicant like more general? It's like anybody that applies for any action in town.
I just made a note of this. This needs to be updated with North Carolina General Statute. Applicant, who can be an applicant, is defined in the narrative of your ordinance. It's inconsistent with that.
So we don't need a definition for it?
Um,
No, you do.
We need the
you,
proper.
you probably do, but an applicant can be anybody.
Cool.
The property owner, someone who has a property under contract. It's defined in statute.
Designated representative of the owner.
Mhm,
It's-
That's right. Yep. So I'll update that with NCGS, North Carolina General Statute. Thank you, Ron.
All right, we'll move on to page 7-6. We are making speed. At the top, under assisted living, nursing, and personal care facility. The second sentence, it starts off, a nursing home. I would like it to say a nursing facility is a home for chronic or convalescent patients. I think it just reads better.
Sure.
And unrelated to the licensee, I guess I'm correct in assuming that that means you're not a family member by blood or marriage.
Yeah, that's the intent. So,
Okay.
yeah.
Okay, and home also falls further on down.
Yeah, nurse provides care for patients who have remedial illness.
So if you could look through there, and not every place it says home, but
Yep.
you'll know what I mean.
And are
I'd rather go to a nursing home than a nursing facility. But
I don't
okay.
know. I don't know.
Automotive.
Yeah, go ahead if you have
If,
automotive.
on
Can we move on?
automotive, either change the category where it says automotive sales and service, because your first sentence is
Mhm.
referring to sales.
Yes.
Which
So
I don't-
this definition has been further updated. I looked at it again because actually what we decided to do is you also wanted to include maritime or boat
Yeah.
sales as well.
Hmm.
So when you get the revised copy of this article, I think it will be probably called. It may be called automotive and maritime
That's fine. That's-
establishment,
yeah.
but
Just
I
reading
think
this.
yeah.
But
So it's
also
going to be generic to both
automotive.
land transportation and water transportation, sales and service, right?
In general, except in here in Sunset Beach, there's a limitation on the rental of maritime vessels only for non-motorized. So,
Yeah,
so the goal, what and this is one of the reasons why I didn't want to rush through Article 3 because I need to make sure that it's clear that that if you're going to rent a maritime vessel, it can only be non-motorized, and so versus folks
Right.
can rent vehicles, whatever, automobiles, different than that. So. And that'll be included.
okay, good. And we were also going to add
Should- I
auto
mean-
glass and upholstery work to the types of work that could take place.
And in bigger picture, maybe should we separate out the service from the sales part and make two separate?
We talked about this, but we
Yeah.
can talk about it again. But
Because
Why not?
because the service part like is the noisier part
But-
generally.
yes, we had a long debate on this, but
Yeah.
the I guess what the position of the board was at the time is that because we had two categories, we had
Major-
automotive major and
major.
automotive minor,
Yes.
and automotive major dealt with those service related items that can be create more of a nuisance. But the discussion ensued that in the districts in which they were going to be located, and in realizing the need for having mechanic shops, etc., that they should just be fine to be in those two districts. And I can't remember what they were. I'm going to look at
Probably
back
MB
up.
one and two. I don't know.
I don't remember it, but it's
You got to find a table in 3, then, right?
So it was only going to be, so it would be in only permitted in MB1 and mud. And that there was no issue with that. There was an automotive minor that was going to be permitted in MB1, MB2, and mud. But that's going to be stricken. It's just going to be automotive and maritime, sales and service, and it be permitted in MB1 and the mud district.
yes. I
Yeah,
agree
we're
with
gonna
that.
combine
Those
those.
designations. I'm
Yep.
looking back at what we
Yep.
had.
And so,
All
I
right,
mean, we can talk about it again when we get to the material.
Okay.
But
So you're saying that you really don't see a need to split them out?
I mean, I did initially, but we
Yeah.
had the discussion that why don't we
Well,
just put it in MB1 and then not have the distinction?
Yeah, because it's only allowed in MB1.
And mud.
Yeah, because I was thinking, I mean, Tesla, when they set up a sales office, it's just a sales office.
That's
Right.
right.
So, which would be an office, but maybe one vehicle,
But-
and then you just go on a computer and order, which
So-
which would seem okay in most cases in MB1 or 2.
But in that case, if it is in fact an office, then it's going to be regulated as an office, regardless of if they sell
Just
cars.
because they're selling automobiles don't make a difference.
doesn't make a
Yeah,
difference.
Okay. I mean, because we're thinking big old fashioned automotive
Correct.
lots. We don't.
Yes.
We're not talking about an auto dealer lot. But nowadays, sometimes they do it with the computer only, and
Yep.
there is no giant showroom and lot anymore.
Well, yes, yeah.
Under awning, the next one, we're talking about a non-rigid material. But to me, and you can have an aluminum awning that still is the same. It's an awning. It just isn't non-rigid. Now, I don't know that this has ever come up, so maybe it's a solution without a problem. But you know what I mean by a fixed aluminum
Yeah, I
awning.
mean, I think that may be, I do, but I think canopy may apply there as well, which is on the next page, and it includes the word structure and enclosure.
But that says fabric or pliable material.
Mm.
So
Yeah,
it's
I got, yeah, it does say fabric or pliable. We can add,
Where does awning come up elsewhere that we need this definition?
it's related to signage.
signs. It comes up with sign
An
area.
Yeah.
awning sign. Right?
Yes.
Yeah,
So I guess we well, it doesn't have to be non-rigid material, right? It could be rigid or non-rigid material,
Well, you can call it any material, such as fabric,
plastic or
plastic, or metal. You know, you just take the word non-rigid out of it.
metal. Yeah, because you could have a metal awning with a frame.
They make aluminum awnings all the time in your
Right.
house.
any material such as, any material
Such as
That-
fabric or
that
plastic.
is, okay,
Or-
but
We know
Or
what
metal.
we know what one looks like, but you got to describe it.
Well, I mean, the only time
I
this
think
is
we could get this such as, sorry, go ahead.
yeah, the only time this is going to come in is if somebody again wants to
Do an awning sign.
install one and wants to argue with me of this is an awning, this is not an awning, or when somebody goes to put wording across it,
Yeah,
calls
so
it a sign,
The awning becomes a sign.
and then I'm more concerned about the square footage of the lettering, not how big the sign, how big the awning is.
Well, this isn't trying to decide the size of the awning. It's
Yeah,
trying to
true.
decide.
Just, I think Pete just wanted to make sure that someone could do the
They could skirt around this by making it out of aluminum.
yeah, I think it's fine. Just call it any material that that is supported by or stretched over a frame,
Yes.
et cetera,
okay.
et cetera.
Yeah, okay.
Sound good?
Yep.
Yep.
Good. Anybody have anything else on 7.6? I've got a couple things on 7.7. Jerry, did you? I heard.
Yeah, the other thing on the automotive, which we're going to discuss again probably, I would add the state inspection as part of the. I know it's a broad
That's
brush,
a good point. Yeah.
but the state inspection would be important.
That's an important service. So it's
Yeah, it
because
does
I
say
said glass upholstery work,
it-
state inspection.
Yeah,
it does say inspections there now, wheel alignment and inspections.
Oh, it does.
Yep.
Yeah.
State inspections would be,
Yeah.
which includes checking the brakes, tires, and everything like that.
Okay. Under bottle shop or wine bar on page 7-7,
Mm-hmm.
are we really just trying to keep it to,
Well, the way this is written, the way I read it, it's a completely opposite than I thought we were trying to get.
We went back and forth on this.
So I either
Um,
misunderstood what we decided on, or
We had a lot of discussion on this because the original definition, if I recall, said that the sale of spirituous liquor would not be permitted,
yes, I think it did.
and we discussed.
Not in a definition, but I think it was in the body of the UDO. But go ahead.
is there a supplemental?
And forgive me, I want to make sure that we have this definition defined with the intent that you guys want, but.
Yeah.
I think I can't recall, but I think we came to the conclusion that if it is a margarita or a beer, and please correct me if I'm mistaken, that I think that you all potentially were okay with it. But let me go back and look at my notes again as well.
Well, let's see. Definition: bottle shop or wine bar, an establishment primarily devoted to the sale of alcoholic beverages for on-site consumption where the sale of food is incidental and does not take place. And then sale of spirituous liquor or mixed beverages not permitted was strucken.
Yep.
But I guess
Remember that.
that's the way the minutes say. But I guess I'll claim I didn't understand that. It seems like the way it's written now, we're not getting to what we want, because the way it's written now, to me, it just describes a bar.
I mean, that's the debate that we had, and that
And I thought we weren't going that way. But
we can. I mean, it sounds like we just need to talk about it again. But that's what I had in my notes to take that out for that reason. The strike the spirituous liquor portion. It can be added back in.
because
but that
Does
was
that
the,
make Family Dollar a bottle shop?
no,
Because they
No.
sell beer and wine and
the distinction is that on-site consumption
right.
triggers it being a bottle shop.
well,
You-
it says on-site or off-site.
Yes, remember you guys also wanted to put the word off-site in there, which I advise against, but that's fine.
Well, I guess what is the planning
comes back
board
to
view
focus.
what
Yeah.
this establishment is? I view it as kind of a wine store or a craft beer like store that sells bottles of wine, cans of beer, growlers of beer, but also allows some, let's call it tasting or sampling. Is this not what this is, or am I wrong? It's just off.
What I understand this to be is you can go there and buy a 6-pack, or you can go there and have a drink and hang out. One or the other.
Which is a bar.
Well, both.
Yeah, or both. And so, yes, it is correct that it's a bar. That I had in there before limiting the spirituous liquor so that it's not liquor. It would just be beer or wine. But you guys tell me what you want, and I'll update it.
Yeah, I mean, it's,
Where do we allow it only where? It's only allowed in,
It being allowed, I believe, in the same places that you'd allow a microbrewery.
which is what, MB 1 and 2?
Yeah, I think that's right.
I gotta find the table.
Well, for
I
instance,
thought there was three pieces
MB 1 and 2
and mud.
and mud.
right. For instance, the Lowe's in Ocean Isle, you can sit down and sample a beer.
Yep.
Now, does that mean that they would be
The
would
difference.
this impact them?
Is
A
the
Mackay
difference
Brewery,
is
for instance, you can walk in and sample a beer, and you can buy a beer.
That would be a brewery, which is
Okay.
a different term, and it is defined in your ordinance.
But
And,
like the
and
one in Calabash, they don't brew there, right?
that's what this would be.
Right.
This
That's
would
what I'm
be-
thinking. But well, I think we're allowable. I don't know, maybe not. I think what we want is allow a place that can sell wine by the bottle or beer by the growler or beer by the can and have some. So maybe we need to undo that change about the spiritus and put that back in or something. Because
What's
I don't think we want a bar. Do we want a bar? Is that what we want?
I'm confused to what you're asking. I mean, we went through this
We did.
Yeah.
We can go through
back
it
in
again
the
though.
day. I
We'll
don't-
go through it
and
a
then-
third time
Well,
too.
I mean, I guess the
Yeah.
question is, do we
Yeah.
want a bar? Bar
We
Well,
got
I think
You
the
guys
question
tell me
is-
what you
with
want.
no food. This allows a bar with no food.
Yes.
Is that what we want or not? The way it's written now, you can open a bar. You can either sell it for on-site consumption, which is a bar, or you can buy the bottle and leave, but you don't need food. You don't have to serve any food.
Well,
the way this is
but-
written right
But
now.
you can
The bar
serve.
would not allow you to purchase and take that alcohol off-site.
It would not. That's
So
correct.
you, huh?
This was.
Yes,
Yes, it
but this would. So,
Will.
and I'm trying to find a definitional line between what I think we're trying to encourage, which is a wine shop, sample shop. That's not a bar. I don't go
So-
there to sit down and have a drink.
I would recommend adding the language that I had in there prior,
Which, repeat,
which I had in there first, which was sale of spirituous liquor is not permitted, and that you can go there, buy beer, wine, hang out, take your family, whatever, or just buy it to go. The general consensus of our local governments is what they generally don't want are liquor bars. That's what they don't want.
Right.
The establishments that are these bottle shops, primarily they're more family oriented. Folks are happy to have those as an option versus the just straight up go in there and buy a whiskey shot and what have you.
So how come you get such a poor job convincing us last time to leave that line in?
Oh, I think that I eventually decided that it was not worth my breath
Well,
any longer.
You
Wow.
convinced us
Good
now.
point.
Yeah, because it didn't matter what I was saying.
all right, are we satisfied with putting that back in where
Yes.
it does not allow the sale of spirituous liquor?
I believe so, because I don't think this is what I don't think we ended up with what we thought we were. Maybe we were just wrong.
Yeah. And
Or I was just wrong. Also.
Well, putting in bars as commercial use is problematic anyway because it really is site specific.
We don't have bars. We have restaurants that serve liquor.
Right?
And I mean, do we want to go back and revisit whether we have bars or not? Or is that something that we want to completely keep off the table?
So you'll get the revised use table, and we can talk about that at that time.
All right, but you're going to add back in minus the spirituous liquor.
Yeah,
Okay. And thank you for your forbearance.
that's okay.
We use the term buffered in several locations in our new section 3, but we don't have a definition for it. I'm not going to hang myself on that.
Buffer.
Yeah, buffer yard. I'm sorry. We use the term buffer yard, and would you think it would be necessary to even define that?
I mean, buffer's defined, and that captures it.
All right, I'll go by that. The building footprint, it talks about including porches. We mean covered and uncovered porches, don't we, as a building footprint, Chad?
Yep.
That is correct.
Do we need to specify that it is covered, or because it says porches, even if it's not covered, it's
Yep.
okay? I'm satisfied if you are.
And just to remind you that the definitions that are not underlined or have a line next to it are existing with no changes that are
Correct.
Yeah.
Building setback lines, we took it off of the measurement section. I'd like to no, I guess we don't need to. I was going to strike the word building and put the word structure in, but on our definition of building, we say principal, we say structure or building principle, so it's already taken care of. Anybody else on 7-7?
I do have one on crematoriums. They're not allowed. Then in the next page, crematorium is defined. The definition, is that because just in case it has to go to a board of adjustment, or am I not reading
I
that
can't
correctly?
recall. Let me go back and look at the table of uses. We added that for some reason. Funeral homes and crematoriums are permitted in the MB1.
Mm-hmm.
All right,
and-
so
So it's a new definition.
So the
So,
definition is needed.
yep.
All right, I have nothing else on 7-8. Anybody else? As we go to 7-9, is that good?
Mhm.
Under daycare facility, child and adult, we started off by saying any child care arrangement. Shouldn't we say any child/adult care arrangement? And
Yeah.
in every place children or child is in there, we need to have put /adult because we're dealing with both child and
Where are
adult.
you at?
But
Yeah,
adult is-
but
I'm
I
on
started,
7-9. Wait,
Oh,
Mr. Chair, I started to revise that, but it seemed more appropriate to add down below what was specific to adult rather than modify the underlying child, because there's a couple differences between the two. I mean, certainly it can be made more broad, but there's kind of a bit of a difference between the two. I think that their impacts are similar, but they are kind of
okay,
different.
you've convinced me.
Okay.
You've convinced me.
backing up to 7-8
Oh, okay.
on congregate. It's only calling out elderly persons. Should we also have elderly or handicapped persons?
Sure.
Because we do define then a handicapped person under the
Good-
age
good point.
section.
Well, supportive services is the same thing.
Well, he's right. It could be somebody that's handicapped that isn't elderly.
Yes.
All right, I'm moving along. I'm finished with 7-9 as well. Anybody?
Could we just
something?
reiterate, I'm not sure I understood this distinction that we made in daycare between children and adult. What was the accommodation?
We'll leave it as is.
Yeah.
Okay.
We just grouped the uses together, and I was trying to cobble together a definition that captured them both, and they needed to be sort of separately worded.
And I agree. It's
Okay.
a different
Yep.
chore,
Yep.
if you will.
Okay.
I'm on 7-10. Is that okay?
Mhm.
Under dock, I'd like to see it say on the second line, into a body of water that allows for viewing or access to the water. Because you can have a dock that you really don't have access to the water, but your dock is there for viewing purposes. And it extends outward from the shore.
And I thought we also added wood or aluminum back on the original discussion, but
Where's that?
typically comprised of wood or aluminum. I had a note that said that, but because not all docks, well, a lot of docks are not wood anymore.
No, they're made out of
they
Trex or
Yeah.
aluminum, yeah. Well,
So I
it
just
says-
had a
It
note.
says typically comprised of wood, but
They're not really anymore.
okay.
I don't have one.
We'll take
so-
it out of there then. We don't care what it's made out of.
Yeah, I guess so. Just a structure that extends along the shore outwards, right? We don't care what it's made of, maybe, yeah.
The only thing that I had is that there was a spelling error there between along shore and but I'm and that was corrected. But I'm fine to. What does it need to say? Structure typically comprised of wood.
Or take out
We're going
the
to strike
typically-
that out of there because it
Okay.
can be
What
made
do
out of
we-
aluminum.
What
it
do
can be
what do
made
we
out
care
of
what it is?
Okay.
straps,
Got it.
artificial wood.
Taken out. Okay.
Um, okay, I'm going to the top of page 7-11.
Uh-huh.
Does anybody
No,
have
we're
gas
good.
with that?
We're good.
The word we're defining here is dwelling, and but it goes to the top of page 711. A building or portion thereof designed, arranged, or used for permanent or temporary living quarters. I was adding the word temporary.
Or take the word permanent out.
No.
No.
Because
Neither.
remember,
Don't do that.
if someone lives there from a temporary basis, that's fine. But it may be that someone can also live there on a permanent basis.
Well, that's
The
why I
key-
wanted to add the word temporary.
But no, but the key is that it is designed for someone to be able to, in the event that they want to, they can live there in a permanent fashion, and that's the point. Whether or not it's a temporary person or a permanent person is
It's a
not
dwelling
not
place.
not the matter. It's that it is a
The design.
yes, that's correct.
It's designed to be permanent living quarters, whether they use it that way
Okay.
or not.
Yeah.
In other
Yeah.
words, you can't have a inferior structure just because somebody's claiming
Yeah,
it's
because
temporary.
because I could say, well, I've got a dwelling and it's a tent. That's designed for my temporary dwelling.
Okay.
It's the design.
Under dwelling multifamily, moving down the page, I had a note that we changed multifamily from 3 to 8. Now, I think it's a hiccup when I was writing the word 3 and turned it into an 8, but didn't.
You're generally correct. The definition didn't change, but you're talking about how we're going to regulate it, and that there was going to be.
Yeah, that's right.
So
Okay.
I don't want to open up a can of worms here, but do we need dwelling triplex in here?
Yeah, I was gonna say. I know we defined triplex and then 3.
But we don't define townhouse. It's
Yeah, we do. There's townhouse someplace else.
not
Yeah,
dwelling.
two-family or duplex.
okay.
Townhouse
All right.
occurs somewhere else. I found it. It might be
it's
in like.
in there. Townhouse
in
is
there.
in
My
there.
fault. Yeah. Sorry.
All right. Anything else on 711?
Yeah, but why don't we put it under here, dwelling townhouse,
We
instead
can.
of searching back to find townhouse
Yeah.
again?
Hold on.
Is it under the T's? I guess.
Yes, it is.
Yeah, it's under
I'll add
just the
it.
T's. Townhouse. You're right, because the pictures there are probably somewhat helpful too, right? So
Also, a dwelling for single family. We talk about, which is kind of archaic now, somewhat archaic, where we talk about septic service for a certain number of bedrooms. But
Which one? Sorry.
under dwelling, single family, and would it be advantageous to say, or one sanitary sewer connection? Now, I guess where I'm going with this is if somebody has they have one building, primary structure, they have a 5-foot wide enclosed section going 20 feet long to another one that they now put in another corporation cock for a sanitary sewer. You know, I don't think that's our intent.
Okay, hold on. Let's talk about the septic. I think it should just say served by one sanitary sewer connection.
Okay.
Period.
Yes, that would solve both of my questions.
All right, and by that definition, could be a septic tank or a sewage hookup.
And you can't have a septic tank anymore.
Yeah, there may be. I
Unless
think
you're in
there's
the
a
ETJ.
handful of ones in the ETJ, but
Yeah,
Or unless the
There are
Brunswick County can't come to you.
Yeah.
Get to you.
yes. Yeah, there are a
Well, some
handful of
that
lots
beach
that's
didn't
sold
want to.
septic.
Including mine.
Okay.
They wanted to.
All right. Did we agree that we're going to move? Going to say dwelling townhouse?
yeah, that'll be added there, and then
Okay.
under townhouse, I'll put a reference to C, dwelling townhouse.
And did somebody say they'd like to see dwelling triplex removed?
No, he was
No.
just he was just curious if it was in there, but it's in there.
Okay. Moving on to, we are lightning speed here. Moving on to page 7-12. We call it an eating establishment. I know this is nitpicking, but it's a restaurant. And we use the term restaurant throughout the whole UDO, so I think we need to at least, in brackets, put restaurant.
Okay.
So that the term is interchangeable.
The table of uses says eating establishment,
Yeah.
right?
Yep.
Yeah. Well, there's also restaurant in the table of uses.
Is there?
It
No.
shouldn't be
No,
anymore.
it was replaced
Oh,
with.
it was. It was.
Yes,
Replaced with eating
yes.
establishment.
Yeah.
Okay. All right. But at least it makes it clear. I have a note here under essential site improvements on 7-12, but I need to read it so I can, because I added the word stormwater after driveways. Stormwater retention areas, because a retention area, you gotta define what it's retaining. A retaining area can be a retaining wall. But we're talking about stormwater retention here. So I'm just inserting the word stormwater. Under feather flag on page 7-13, it contains a harpoon-style single pole, because a feather flag is a single pole. Now, I know I'm differentiating it. If they have two poles on it, it's no longer a feather flag, it's a banner.
Okay.
Single pole.
Yeah, inserting the word style single pole, or style was there.
Can we go back to family care home for just a second?
Please.
Can you help me understand, how is this different? What is the intent of creating a difference between?
One is residential and one is non-residential.
Okay, one is residential. Okay. And are we satisfied, and I haven't read it, but are we satisfied with having this defined by the North Carolina statute? And does the North Carolina statute include homes specifically for counseling services?
We're required by statute to and fair housing laws to make accommodations for up to 6 unrelated persons for this use. It's a gray area from 6 to 8. We had this initially at 8, but we've taken it back down to 6.
And that's fine. There are homes that are predicated on counseling services. My concern specifically, typically for alcoholic counseling services.
You mean someone that like goes to you mean a recovery house type situation?
Correct.
Yes, this is basically that. And
but
and we're allowed to have a half-mile separation on them by statute, but we got to define them and we got to call out that the reference to it.
But is that reference included in NCGS 16?
You've also got a supplemental regulation in here that says that they have to be separated by a half mile.
Yeah, but that's not my point. My point is there are, I know of one in Calabash, for instance. That is
We
a
just
residential
went through
community.
a lawsuit in Calabash precisely related to this.
Yeah. So does this exclude that kind of use or include it?
We have to accommodate up to, the statute says
Within a half a mile.
up the case law and the statute say we got to allow up to 6 folks. You very likely may get sued if you prohibit them up to 8, but
Right.
that's a gray area in the law. So you have to. You have the bare minimum in here, period.
And maybe not I'm expressing, I mean, this is a person with disabilities.
That's right.
Understood. Does
That
that disability
yes.
designation include
Yes.
counseling services for alcoholic
Yes.
residents? Okay,
Yes.
thanks.
Moving on to the middle of page 7-13.
No, food truck was supposed to be fixed.
Yeah, I think we need to take that out.
Can I get it? Where are we on food trucks?
Actually, no.
I'm not there yet.
I'm sorry. We need to leave food truck there because this has now been changed to say it's in here, but it's calling out that if you're going to do the food truck, it needs to be permitted based on a special event.
Yes. Yeah.
So actually, it
Yeah,
needs to be in here.
but I thought we fixed the 2 or 4 employees was to up to 4 employees. The or is wrong. I think it's in the minutes too.
Okay, up
Right.
to.
Well, we got usually room for 2 or 4 employees. Well, what about 3? I thought we fixed. It's in the minutes that we discussed to take the or out and make it 2 TO, 2 to 4 employees, or if you want to change it to up to 4 employees,
Okay,
whatever
that's
you
Right,
feel
just-
better with.
just-
I just
2-4,
Well,
whatever you want to
Or
say.
up to 4 employees, whatever's more legally appropriate for a
Okay.
definition.
Also, with that, I've got something previous to that, but I'll go back to it. But didn't we want to commingle this with mobile vendors?
we did, but that mobile vendor is going to come out altogether, and food truck will now only be related to special events.
Special events. That will change pretty soon, I'll bet. But okay, it's
But that's yeah.
under finished ground line. Now I'm gonna preach, not preach. I'm
Excellent.
gonna let my thoughts be known, my position be known. I am very much against, as an example, in MR3 having any structure that's taller than 35 feet. I don't care about the setback. If you increase the setback, that you can go up for every 1 foot you go further off the street, you can go up 2 feet. I think a bigger building that's 2 feet back or 10 feet back from its front setback stands out like a sore thumb in a neighborhood. And I think it's not the architectural view that I want, or that I think our citizens want. I would like to at least make a statement that we're measuring finished ground line from the front of the building, or on the beach, or on Main Street on the ocean side from the back of the building, and we're measuring it from there. I would like to see it that it's the average finished grade of the lot measured at the average of all combined sides of the building. And just because you have a fall off in the back of your house, it now allows you to only take the front grade, which can be 6 feet, 8 feet higher than the grade in the back, and then you start measuring your 35 feet up from there. I think it changes the personality of our neighborhoods. I'd like to see it across the board changed, and I think we're at least, when we go back on phase 3, I'm going to have that discussion. I'm waiting to see how my suggestion for the setback in the various zones, how that is dealt with in our draft that you're going to send us.
Yeah, I mean, I was just updating MR3 that no residential or no 1 and 2 family can be above 35 feet, but which is, I think, what we agreed on. But I mean, if you change
But
that,
you have to know how to measure it. You have to know where it's measured from.
yeah,
And
yeah,
finished grade starts that process.
yeah. Let me pull up the height
Yeah, because
definition.
considered to be the average.
If
finish
you,
And I don't know why we did it on the beach either. It's
this, I mean, the fill thing has been discussed for years, and that
I know.
because there's a difference oftentimes at the rear, particularly on the beach, is most evident, because you've got
Blocks the view.
you've got but you've got a retaining wall oftentimes at the rear of your house on the island.
Uh-oh, I said something wrong.
But I mean, I think that the fill regulations have been working on establishing finished ground level.
Let me ask the other planning board members how they feel about heights of structures. And I'm particularly talking about residential, but it also has to deal with commercial structures as well.
Yeah, well, this is one of those issues that I agree with you is critical to the nature of the community, and I'm not as well versed in the specifics of how this is measured, but I get your point in that absent a really sufficient definition that doesn't allow for any wiggle room, can be a burden to the staff, but it can also prevent the kind of things where you get a household stuck in the middle of somewhere that really defies the overall atmosphere that we're trying to sustain in the community. The details of how you do that,
Well,
what you bring to our attention is this is a spot where the devil in the details can come back and bite you.
So I mean, remember this definition is considered to be the average finish elevation of the entire lot, but we have to choose a point at which to measure it, and that point
Well,
at which to measure it
It's
is
easy. You take the average elevation of all sides of the building and you divide by how many sides of the building. And that gives you a datum point to start measuring height from. If
So
you
what-
take it just from the front or just from the back, you will have lots that are going to take advantage of it.
I mean by inches.
No, by feet, by many feet, by
What's
many
your-
feet.
I mean,
so
There's lots on my
let's-
street right now where the difference in elevation between the front and the back is 8 or 9 feet, 8 feet.
so sloping forward,
And
or
he lives
rear?
across the street from one of them.
Sloping forward or rear? Chad, what's your? Let's pull in the person that's got to have to administer this in this discussion because
I think you're opening up a can of worms.
I agree. But
Well, but what he's saying is you could, and I maybe don't
No, I get
understand
what
it.
he's saying.
So you got a sloping lot
No, I know
that could
what.
slope in multiple directions,
Yes.
right?
Yes.
I think what he's concerned about is that if the front edge is the highest part of the lot, you get 35 feet from there. But when you look on the other three sides, it's 40 feet.
yeah.
Right.
So, well, tell me, Ron. Then, if you're building that house, so like in inland, let's say in a community, say Winston-Salem or somewhere in Raleigh, you have what's called a walkout basement in that instance,
Mhm.
correct? You don't have a house that the roof slopes backwards. So, I mean, do you guys want to require that the roof slopes
No,
backwards?
No.
Okay.
You find finished grade by averaging the total perimeter of that building.
So,
And you come up now with a datum point for your finished grade level.
so you would, so then,
So you
if
might
it-
get-
so then you got to, so then the front of your house then, where you may get 35 feet, now all of a sudden it's got to be 25 feet.
Yeah, to get the
And,
average.
and so are you
Let's
wanting
say
to
there's a
do
10
that?
foot. Let's just say there's a 10-foot slope.
Yeah.
That means to
Well,
be
that would be-
35 average, you got to be 30. You'll
Well,
be
you-
30 in the front and 40 in the back.
Yes, it would be a 5-foot differential because you'd
I know,
take
I'm
half
being,
of the
I'm being
difference.
hyperbolic.
And that would
but,
be the furthest stretch you could ever see. So,
I mean,
We thinking that's too restrictive.
but they also have the ability to build up their lot too, based upon the elevation of the street. They can go 1 foot above the crown of the street.
Depending.
Well, yes, there's other extenuating circumstances, but as a general rule.
so then they got to bring in $50,000 or $80,000 worth of fill to be able to get their additional 5 feet,
Yeah.
and that they can get anyways.
Again, is this really a problem? Because I don't know all the spots in town exactly. So, but don't we kind of really want the fronts to all kind of line up? In other words, unless you got a street that's got like, I don't know, maybe we do. I guess I haven't don't drive down all the side
Not
streets on the
elevated. Yeah.
that you got a big hump, and then, I mean, you kind of generally want like all your fronts, because the setbacks are the same, to be about the same height, right?
Since I brought this up, how about if we think on it? Because I'm talking about really an overall concept, not just this definition. And I think that I've broken my own rule here. But I think the definition of finished ground level does need to be looked at. And how about if the planning board just takes that under consideration? Drive around, look at the new homes being built.
And I would,
Pete,
and
let me
I
ask
would,
you-
Chad, I would be interested because I mean, I see Chad kind of.
Well, and
I would be interested in terms of what you see. A is the impact of leaving it as it is. A, and B, the advantages of attempting or the difficulties that might be created by what we're suggesting, and get back to us with something on that.
my question comes to the board on one thing, and it may just come down to Pete, is when you look at homes that are affected by this, you look at you measure from highest adjacent grade, from the ground, from elevation to the top of the roof line, you're probably looking at no home being over 40 feet. But when you take into consideration that highest adjacent grade, every one of these houses are below 35. I mean, I look at every one of these things, especially if they come in on the beach, but they have an elevation certificate. If anything comes into question, Carrie and I realized that we take a tape. I mean, there was a house a couple weeks ago that Eric and Carrie went out there and took a tape and dropped it from the top of the house to the grade, and there was concerns, and we were right. It was over to the point where the contractor had to alter the structure to get it below the required height. My question is that if I can bring Carrie in here, I think I'd also like to potentially bring Richard in here. Is the concern from a fire standpoint?
Well, we're equipped now to do the Regency, which is 5 stories.
So
we're
my biggest
that's going to be our
question is-
denominator, not a 40-foot tall.
It
house.
works the way it is. So my question would go back toward if our ladder truck can potentially handle it. What's the concern?
I'm mostly satisfied that we are in MR3 at least, saying that the maximum height is 35 feet. In other words, not allowing people to increase the setback to go up with height. That's more important to me than measuring finished ground. So I brought it up. I'm going to put it aside.
Okay.
Think about it some more.
How about this? We do this though. I think it would be appropriate to strike for septic tanks and septic fields and just say before landscaping
Yes,
and
that
fill period.
has nothing to do with it.
Okay.
But I do believe, I think this is an
I lost my
important issue
place.
because we're going to be getting a
On
lot
the
of
finished ground line, we're taking the last
development
few ones.
requests
Yep.
for new housing
Page 7,
and multifamily. And, we want to make sure that this is whatever the standards we create, that they're locked down
Sure.
tight. And that, what Pete raises is
That,
an area where I don't think they are.
I'll just say this, and then we'll move on. Over the years, this debate about fill, has been refined a lot.
We've done a good job of it.
And I just want to make sure that we don't try to untangle this web for in 5 instances that may occur.
I'm willing to step back from it.
Okay.
It's,
Okay.
Yeah.
under floor area, we provide a nice definition here. This is still on page 713. But we repeat the same thing in the body of, this would be under section 322D4. And if we have a definition that says that we don't have to, chapter and verse, repeat the definition back in, it would
Probably
be on
not.
page 3-75.
3-22.
3.22 dog 4.
What page is that on?
3-75
Okay.
in our homework assignment. We repeat the definition and underline it, and we do it word for word. Take it out of there.
Take it out of 3-75.
Yeah.
Okay. Yep.
Yeah.
Got it.
All right, you already talked to me about mobile vendors. We removed the definition for garage private.
Yep.
Um,
How come?
well, I guess it's either an accessory structure or it's part of the primary structure.
Yeah.
So it's
Yeah.
okay.
On the golf stuff, we keep saying not miniature golf courses, but we never define a miniature golf course. Is that necessary?
It's included in, I believe it's
We have it in
included
a-
Where?
in commercial outdoor recreation.
So we don't need
Somewhere.
a definition?
Thought it was defined somewhere.
It is there, miniature golf under commercial recreation outdoors.
Yep. That's what I thought. Yep.
Okay.
Where is it at? What page?
That would be page 7-8 of the definitions.
7-8.
Yeah.
Yep.
It's under commercial recreation outdoor.
Yep.
Examples include water parks, mazes, and miniature golf.
Okay. Right.
And
So
golf,
we'll just
yeah.
take in the colloquial definition of miniature golf.
Well, we still haven't defined miniature golf. We've just
Right.
referenced it. But Hello.
That's not good.
Sorry, folks.
Well, I was wondering, do we need a definition of, because we keep saying,
I don't believe so, but
'Cause we
we
say-
can add one if you want.
yeah, because we keep excluding it.
But,
but-
we're defining golf course and golf driving range. I mean, if I'm pretty sure we know what miniature golf is when we see it, but we can put one in here.
Well, Jerry, what would the definition be? Less than a championship course?
But one uses
Well,
the
that's
putter only.
probably less than championship. No, I
Yeah.
think the way that they have this golf course lined out, I think it's
Okay.
well explained. Other than it's got to be a minimum of 2,000 yards. I would add to make sure there's no
Consisting of a minimum.
a minimum 2,000 yards.
Got it.
And the typical executive par 3 is probably what, Jerry?
If you
be
compute
anything.
this, it's 9 holes at average of 222 yards a hole.
Right.
So you're gonna have 1 or 2 par 5s. So you're gonna have the majority of par 3s.
It's
So
not an
without,
executive.
it's executive 18 holes would be
Par 3s,
be
150.
4,000. So
Yeah,
I think
all right,
they
so we're good.
described it. Yeah, I think it's perfect.
Yeah,
All
I
right.
agree.
You're satisfied as the.
Oh,
I have
That's all
some.
the grass.
I have some concerns about golf driving range. Is this where we would include a definition that precludes the kind of top golf structure that could be considered a driving range? Because that's coming. And that would
I
include,
thought we discussed that Top Golf somewhere was not part of an indoor. It's a indoor facility. I forget what the
Well,
conversation.
it's not
was.
necessarily
Sorry, indoor.
Just
yeah, it's
Outdoor.
to be covered, but it's.
Yeah,
I mean,
T is
quite
fine.
often there are structures that include 2 levels of
I thought we have some supplementals
did.
for golf driving range that we discussed. I don't know, pull that. That this would not be the place though. The place to talk about that is when you get Article 3 again.
Okay.
7-23 deals with that.
that's fine.
And page 3-40 because page 3-40 has the golf driving range use standards, which have fixture heights, lighting requirements, hours of operation, things of that nature.
Okay. So this is not the place.
Yes, sir.
Okay, thanks.
Bear with me 1 second. Miniature golf is really dealt with under supplemental regulations in pretty good detail. And
Golf driving range is as well.
yeah,
That's on page 3-40.
yes, okay.
Golf driving range is on 3-40.
Page 3-40.
Under ground level, we reference several times in the UDO natural ground level. And I'd like to see that ground level have like brackets that say or natural ground level or AKA natural ground level.
I need to review that before we change that because that could impact a host of things.
Well, are you saying because that has to be original ground level even before
I
any,
just want to make sure
any drainage
arbitrarily
considerations?
putting in there doesn't mess up because there's a chain of different related definitions to fill and height, etc.
Mhm. In other words, you could say you could change the ground level with other, with your ability to develop your lot or drainage considerations.
Well, I would prefer to leave it as is. The key is that we're determining what the finished ground level is, and then we're measuring height from that, whether or not it's the natural ground level or whatever it is.
I'll strike that, but I'll
Okay.
go back and relook
Okay.
at it.
Okay. But I've got a note here to take a look at it.
Under home occupation, I'm on page 715. we say any occupational profession carried on entirely within a dwelling. What about if they have an occupation that is immediately outside the dwelling?
Then it wouldn't be permitted.
I think this is an attempt to codify the remote worker.
This does not have to do with remote worker.
Mm-mm.
I see where you're going, but you answered me, because really there is a huge difference between something going on inside the home as far as disrupting the neighbors, as opposed to it going on outside the home. Like if somebody has a daycare center, well, I won't go there. But I can see the difference, so I'll strike my suggested change.
In hotel, motel, the word, well, previous discussed, the word or permanent should have been struck.
Yeah, I agree, or tenant
Well, from reading the minutes,
instead of guest.
it should say transient guest. The word or permanent was to be struck.
Well, tenant also was to be struck too. I
Not
agree with
according
you.
to the minutes, but
All right.
I'm just looking at the minutes. We say guest or tenants was not struck. So I'd have to look at the notes on that. But I'm reading the minutes from
Okay.
page, the minutes for that meeting.
I'll go along with you. The permanent should be struck.
There's actually 1, 2, 3, 4, 5 definitions there that were addressed. The food truck, the hotel, the maritime rental, pure public, and utility services small. That was, what meeting date is that? That's the meeting date of January 19th.
And
Do you see that, Wes?
Yep. Yeah. Yes. And there will need to be a. Yep. So strike permanent and leave guest or tenants.
are you going to have a transient tenant?
I don't know.
I won't go. I'm not
Okay.
going. I'm not going to polish that
Yeah.
word.
Okay.
It talks about motels with individual access to the outside. But what difference does that make? I mean, it's a hotel motel, whether it has access to the outside or not.
That's
That is
why
the
they've
difference.
been.
Yeah,
That is
used
the
to-
difference, but that's why they've been combined.
Yeah. Used to be the motor hotel, that's motel.
Yeah.
Because you had to park in front. That used to be the original
I know.
description of a motel. I think it's fine the way it is. But
Okay.
Okay.
All right. We're under 716. A concrete paver, this is under impervious surface. Concrete paver is not impervious
Depending.
unless it's designed. It can be designed to be pervious.
Previous
That's
papers,
correct.
yes.
Now, our town park is a perfect example of the walkways that go around that. If it's designed by an engineer with a joint opening that's wide enough, it can be, and it has a certain type of subgrade underneath it. So there's not a woven fabric underneath it. It can be construed as pervious. So under concrete pavers, which we added here, under impervious surface,
Should add previous papers.
unless designed with sufficient joint
It-
openings by an engineer.
It goes on to say that below that so I mean
Well,
we
it talks
can
about 57 stone, yes.
yeah
That's
I know
just gravel, that's not
yeah
concrete pavers.
that's right so in other places we've added there's a sentence that gets added that that a pervious surface can be anything that is designed to meet the hydraulic conductivity.
Is that in a definition here somewhere?
No, but it can be added. And
Okay.
and what we can say is that a pervious surface may be anything that's designed with a hydraulic conductivity greater than, etc., as attested to under seal by a licensed and professional engineer. So in other words, someone could submit a, some alternative material that's not here, and they could put under seal that says it meets this conductivity, and Chad could say, okay, that counts.
Okay, but it,
Are you comfortable with that?
Yeah.
Yeah.
okay.
And that would go beyond just concrete pavers. That would mean a range of materials.
And most of the time, when it comes to impervious surfaces, it comes down to the most of the time the literature that comes with it, and also the assistance of Public Works with their expertise coming into this as well.
Most of our people think that concrete pavers are pervious, and they ain't.
That's right. Unless they're designed correctly.
Unless they're designed
Yeah.
for it, yes.
So that means we're adding a pervious definition.
You've got pervious is included in there, and this is related to the statutory definition, and so. And I mean, I guess we could call this definition impervious and pervious surfaces.
Why don't you just do something with
Okay, got it.
Would it be better to or separate it? I guess. I don't know.
I'm on page 7-17 under marina. And in the second line of this new definition wording, we say harboring or storing of 2 or more boats, pleasure and or commercial, in parentheses, and or providing marina sales. So I'd add the word or to
Got it.
and.
Yep.
Because you don't have to, you could do, okay, you know what I mean.
Yep.
Under mail service, because somebody sells greeting cards, to me, doesn't mean that it's a mail service. So I'd like it to say stationary shipping materials, not just stationary. In that first line.
What do you want to change?
I'd like it to read mail services, a commercial business which conducts the retail sale of stationary shipping materials,
Okay.
comma, provides packaging, and then and or provides mailboxes.
Okay.
Under microbrewery, is it legal in that very last line for us to say, number 3, give its products to its employees and guests for consumption on premises? You
I mean,
can't
that would
give,
be
you
for-
can't give alcohol away to people.
Maybe that I mean that word is used being, taken out of context. Provides
Okay,
would be better.
yeah. What do you guys think,
Yeah.
planning board?
Mhm.
Yeah.
Um,
Small thing at the bottom of that page there, that NPDES probably got moved to the other section.
Yeah.
if these-
Thank you.
National Pollutant Discharge Elimination, because it's got no definition here, and its heading just stayed behind.
Yeah, we can probably just strike that, honestly.
Yeah.
That's defined. We don't need it defined here.
bear with me a second because I got to see if there's a. I'm looking for manufactured or mobile home. I want to see if there's a dwelling. There
Out of
isn't.
place.
We've took out the definition for that, but I mean we still allow manufactured or mobile homes. And under modular home, we use the word. We start off with the word manufactured. A manufactured. We have
Yeah,
specificity.
I wonder if that somehow got missed. That manufactured is not in here. It should be in here somewhere.
I didn't see it.
Okay,
I looked under dwelling and I didn't
that's
see
a
it.
mistake. Let me add that.
But under modular home, we start off with the word a manufactured building. It should just be a building
Yes, but,
constructed of prefabricated materials.
but okay.
So we're adding a definition of a
I
manufactured
mean,
home?
I realize I'm changing a noun or confusing a noun with a verb, but it's,
Well, modular is still manufactured.
It is manufactured, but it's manufactured and then brought to the
not on its own chassis.
not on its own chassis, but it meets a certain code. But
All right, if you add mobile or manufactured home
I need to
a
add
definition,
manufactured home. I don't know how that got. Thank you for catching that.
So we're going to add a definition of manufactured
You have
home?
one in there already, and it's one that we've already reviewed. It somehow has gotten misplaced.
Under model home unit, doesn't that model home, or don't we want that model home to be located within the subdivision?
Mm-hmm.
And
And I believe that we might have referred to that now as a real estate
Yeah.
sales office.
Well, there's a difference.
There is a difference because I
I
think
mean, there usually isn't, but there's a,
I believe that we struck model home unit and we're now referring to it as a real estate sales
office.
Yes.
Yeah, but they could have a separate model home.
Yeah, you could
But-
do that in a,
All you're saying you want added there is that it's inside the subdivision, right? Right? No?
Yeah.
I don't see real estate sales office. I see
I'm
real,
trying to pull up
Re-
the temporary uses.
Well, I thought there was a definition
It's
for that that
so-
allowed for a real estate office.
On page 3-49, it's called a temporary real estate office.
real
So-
estate sales. Yeah, okay.
I need to combine those definitions or provide one that meets that appropriately.
But we do want it to be within the subdivision.
It will be, yes.
Okay. Because I mean, they could put it out on Main Street somewhere,
Yeah.
saying they're representing a subdivision that's 5 miles away. Okay, going to 7-19, Sybil brought to my attention this morning that under non-residential use or district, we've talked about BB2, and there is no BB2 section. This is on page 7-19.
It's BB1.
It's BB1.
Thank you.
And under Office General, right below it, we repeat real estate sales office twice within the same sentence. I'm just saying to make it read better.
Got it. Okay.
Okay, I'm on to page 720. Does anybody have
I'm good.
anything before that?
I'm good.
Under public peer or peer public on 7-20, our present Sunset Beach pier is a private pier. It charges admission.
Yeah, but it's available for the public. Even though they charge admission.
Okay.
I don't understand why it's twice.
But yeah, so I wonder if we need a pier dock used by the we had a discussion about this.
Well, we had one definition and we put it into two.
Yeah.
Yeah.
But a private pier is not a pier dock used by the
The
public.
public.
It is.
Private.
It's a private entity. And
Yeah, but I guess so. The private pier maybe needs to say,
We have to take public out of that, right?
I mean, but it may be a private HOA pier, for example, that's used by the neighborhood, not necessarily the general public. So
That's the neighborhood. That's not a.
that's not the public.
it-
I think we can just say pier dock use, pier dock utilized. Let me work on this. Utilized by a a neighborhood or
Something
a
else
private
you-
entity for the purposes of et cetera, et cetera.
And something else to confuse the issue even more for you is under public pier, we say not for boating. We had a public pier is a pier or a dock, and right down at our boat ramp, that's Wildlife and Fisheries controls.
Mhm.
That dock is used for boating,
Yes, but that's a different thing. That would be under the word dock.
but it says public pier, a pier, dock, or wharf used by the general public.
But you would still have the definition of
Think
for
about
dock
it.
to-
It's
okay.
this whole thing kind of commingles in there.
I just called it a twofer. Two things saying pretty much the same thing, but yeah, it does need to be
Yeah, because we have dock.
separated somehow.
Well, that's fine.
there was some reasoning for this. I can't recall
Yeah,
off the
it-
top of my head.
I remember distinctly talking about it and separate. Oh, they need to be separated, and now you separated them, and it's confusing.
I guess, do we need the but not for boating in that definition?
I had a point with that too. Boating, I said docking, but
I mean, because the dock is defined.
So the intent is that this is really, I mean, the public pier is intended to be oceanfront pier. You're not going to use that for boating.
correct.
But I think dock was also kept in here.
But yeah, but if you look at that, then it leads you back to the other definition, which says it's for boating, right?
Yeah, maybe we just need to take out the word dock.
Take out the word dock, so
Yeah.
it's not, it doesn't
Yeah.
go from one to the next one.
Yep.
Or back to the first one, other one.
Yep.
Okay.
All right.
All right. Moving on to page 7-21. Refresh my memory, Chad. Do we need a definition for public utility substation and make it and it's a special use? We took that definition out of here.
We remember we created the utilities, the two categories of utilities: utility services large and utility services small.
Or maybe I missed that.
Yeah, it's
And that's on page
32.
7-32. Because we had a host of different utility definitions.
Okay. All right. Never mind then. I missed that. My fault. I'm moving on to page 7-22. Under residential use or district, don't we really want to say to include any zone that allows any residential use? Instead of trying to, like we've left BR1 out of it, we've left BR2 out of it, and
That's a mistake.
they are residential.
Yep, those need to go in there. I don't know how those got left out.
I always have gas when I see us listing each zone, because if we create a new zone that would be applicable to this, we'd have to remember to go back and include that new zone in this. It's always problematic when you try to be specific.
I agree. As are these ordinances. But there's also CR2 that we added that will go in here as well. I've added a note on that. But there's a lot of references to residential uses or residential districts throughout the ordinance, and also in terms of the applicability of buffers based on whether or not you're a non-residential or a residential district. So we've got to call them out somehow. And that's the intent of this.
Right above that, I'm just seeing it now under religious institution, we repeat the word together with its accessory buildings and uses
Okay.
twice.
Yep.
Within the same line.
And which building is maintained. Got it.
Okay, I'm moving on to 723. Does that?
I have just a question.
wait.
Go ahead.
Okay.
Uh,
Let Sybil go, please.
Under retail sales D, I didn't think we allowed that.
Retail sales.
D.
Yes. Yeah, that you
Retail sales does not include the following.
Yep.
So that's a
So D, it would
not
not
included.
be allowed, and D would
It-
reference
it-
back to
it-
adult business.
That's right. So you would go back to, so those A, B, C, and D are things that are not covered under retail sales.
Retail sales does not include the
Yeah.
following,
Yeah.
A, B, C, D.
Okay.
But good question.
on
Go ahead.
continue on retail sales. We want to make sure we got retail sales major, which are not allowed in BB1.
Mm-hmm.
And we're saying that a major one is a retail over 5,000 square feet. And then a minor one, obviously that is under 5,000 square feet, but does not include a drive-through. So you're automatically a major if you do have a drive-through?
That's the way I read it.
So in other words, you're say you're under 5,000 square feet, but you have a drive-through, like a little coffee shop thing, coffee pickup
Then
thing.
you'd be a eating establishment.
And what's the drive-through doing in there?
Well, it can be like a pharmacy.
I think the intent was not to have drive-throughs associated with any. The key of this retail use is to limit drive-throughs and it just be a standalone structure, a smaller footprint structure.
In other words, traffic doesn't back out into the street. Or
sure. Yep.
that satisfy you, Ron?
So a drive-through coffee
So
shop,
it's just-
say like a Port City Java or
That
a
would be an
Starbucks.
eating establishment.
Beg your pardon?
Eating establishment.
Well, then that drive-through part doesn't need to be there. It's just a size thing we want. Over and
It
under
can be
5,000.
taken out. But remember, that's a different use. A retail use is a retail use. A restaurant or a eating establishment use is a eating establishment
Well,
use.
I thought
Okay.
do we want drive-throughs? We're doing this to try to discourage drive-throughs in certain areas.
That's, I believe, was the intent of this. I'd have to go back, but yes, I believe so. That was the intent of adding that in there.
I don't have a problem with them, to be quite honest.
But we can take that
Doesn't
out.
bother
I
Retail-
don't care.
It's,
Ron, you brought it
think
up.
the
What do you
drive-throughs
want to
I
do?
Just
and I would hate for
I'd
them
have
to
to-
be
I don't know.
eliminated.
So a retail sales establishment
We're not
So,
gonna have
but-
that
a
is not greater than 5,000 square feet. Period.
So this doesn't, because restaurants, others are not considered retail sales, this does not apply to them.
Correct.
Okay, so if somebody wanted to open up a sip shack,
No, that's a restaurant. He's saying.
okay?
Well, that's why I use the word pharmacy. I'm trying to think of something that has a drive-up window
Right,
that
right.
would be retail.
Right, a bank,
Okay.
a.
Because retail sales, right above it, to going right to Sybil's question, B, if it's got a bar, nightclub, restaurant, or eating establishment, it's not retail.
Yep.
So
Can I ask a question?
Please.
Does the 5,000 square foot, is that something that's really important to these two definitions?
yes. It's
Okay,
worth-
I mean, so if it's over 5,000, then you really shouldn't have a drive-through because takes up too much room, or?
No. The key here is that we're trying to differentiate certain uses that may go onto the island, in particular, in the BB1, so that you're limiting your larger, for example, beach stores
Well, then why
or
don't
your
we say
Dollar
that?
General.
Yeah, because
Well, you can't call it a beach store. You got to call it a retail store, and you got to base it on
Yeah.
the square fottage of the
So
building.
You gotta base it on
a
something
ma-
other than
Okay, that
what
makes
they-
sense.
a major is not allowed in BB1. Only a minor is.
Yeah.
Yeah.
So
It
I guess I guess I'm leaning toward just striking that whole drive-through thing and just do it on the square footage.
That's fine.
Does anybody else,
No-
Chair?
no problem.
Well, then my question is, if we're trying to prevent drive-through, how do we do that in those applications that are not included in retail sales?
All right. So
Is there a
The only
place where we
the only thing
do
I
that?
can think of is somebody selling lottery tickets, and
Yeah.
it's a retail store, and they've got a drive-through window. A bank is going to have a drive-through window, but a bank is going to typically be,
Mhm.
I don't know if it's going to be bigger than 5,000
So
square
it's
feet.
not retail.
it's not retail either. Yeah.
It's,
Right.
Is it?
It's paragraph C above.
Yep.
It's a
it would-
financial services.
Yeah, that's right.
Still
Or it'd be an
Oh,
office.
okay, yes,
It'd
you're
be
right.
an office.
You're right.
Right.
Okay, but it still doesn't answer my question. We're trying to eliminate or discourage
Mhm.
drive-throughs. Right now, we've taken that out. That's fine, because I don't think it's very applicable to those things. But in those that we exclude from retail sales,
Yep.
how do we I mean, in Charlotte, there's a place called a Sip Shack. Tiny little booth. You drive through, you get your cup of coffee, you drive out.
Yep.
Okay? Now, if we're trying to discourage that kind of establishment, right now, I don't see where we do that.
You don't. I don't believe. I need to go back. I'd have to go
Then
back
we
and
might as well take out include a drive-through from here then.
So yeah, if you want to discourage drive-throughs on the island, then you probably need to specify that no drive-through will be permitted in the BB1.
Where would we do that?
Probably eating establishments. But you could also this could also be a catch-all. Let me see what we. I don't think that we differentiate that, and I can't recall the discussion that we had on this. If we had a discussion on it, or if there was a position of the board on whether or not you wanted to discourage drive-throughs.
I don't think we've had a discussion on that.
And maybe we haven't. Yeah.
And there are going to be establishments that typically deliver their services, particularly food services, via drive-through.
But I haven't, like in shopping center, it says specifically, so we did have this discussion. It says within the BB1 district, no individual establishment shall include a drive-through, nor be greater than 5,000 square foot in floor area. So
That's only BB1, right?
yes, because I think that we had the discussion that on the island that there's a preference not to have drive-throughs.
Yeah, I have no problem with that.
And that's probably why the drive-through
Should it be
is in the
done?
definition.
Should it be done the opposite way then? A major retail establishment is more than 5,000 feet or includes a drive-in through. And that would eliminate it from BB1. Because major is not allowed in BB1. So a major retail establishment has more than 5,000 square feet or has a drive-through.
I don't know. I mean, I had it that way for a reason, but I'd
Yeah.
have to go back and look.
Well, I think it's both saying the same
Does
thing.
it?
Yeah.
I mean, I'm satisfied with the language that prevents it from BB1. What I'm trying to get at is, it seems to me that on the mainland, we don't have a definition, and maybe we don't want one. I mean, the Sip Shack in Charlotte is a perfectly nice
there's
place
no-
to get a cup of coffee, but if we're going to discourage drive-throughs, right now
Where's the table?
it's wide open.
Table.
I mean, in this situation, I mean, listen, there's places in certain states where you can drive through and buy a beer. So, it just seems to me that needs to be addressed somewhere in these specific applications that are no longer under the umbrella of retail sales.
We're gonna,
And if I've opened a can of worms here, I apologize,
Well,
Wes.
No, it's fine. Let me just ask this question. Can we get it doesn't have to be a vote, but does the board, I think we don't really care about drive-throughs.
You want to make drive-throughs special use?
No, I don't think does the board doesn't care about where drive-throughs are on mainland, correct?
Correct.
Okay. On the island, does the board want to prevent drive-throughs, or do you care?
I don't.
Is it fine?
living on the island, I don't know where you're gonna put a drive-through.
Okay.
I know.
don't
I
think there's enough
can't even
space.
imagine.
So sounds like that.
Yeah.
If someone wants to put a drive-through, is that an issue
On the island?
on the island?
Well, like
if-
Jerry said,
regardless of whether
where
or
in
not they
God's
can
name
fit
would they
it.
do that?
But
Yeah, I think we can.
forget about whether or not there's a place to do it. If someone were to figure it out and do it, would that be problematic?
How
I-
could, I'm just going to say, how could we legally not let them do it?
You can regulate the location of drive-throughs. You can say that there's plenty of places that they're in certain zoning
But-
districts they
Jerry,
don't
you live
allow.
on the island.
I guess I would be, it takes away from the island itself. I think a drive-through is not suitable for the island.
I'm with him.
That
So
was a drive-through laundromat.
that's two.
So what are we going to do? Leave it the way it is then?
Well, what I would do is also add out under eating establishments, I'd also add a clause that says within the BB1 zoning
Okay.
district,
Okay.
drive-throughs shall not be permitted.
Which is fine. So we've dealt with the island.
We
Where
said
we-
that there's no issue elsewhere. Drive-throughs can go elsewhere.
So we're not specifically prohibiting it, so someone could petition for it, and would that be up to the UDO administrator to approve it, or would they
No,
have development by right to put the drive-through?
I've got an issue with that. I mean, we can have applications coming through with people wanting to change uses under, let's say, conditional zoning, and I think, of course, I guess under conditional zoning we can look at that site specific, and MB2, I guess, would be a place where there'd be a drive-through, possibly,
There's not a.
and that's not a
I would
problem.
need to review this, but I don't believe there's a limitation on it.
Yeah, no, there's not.
So we're
I
gonna,
guess I have to say, it doesn't matter.
so it doesn't matter, so, and drive-throughs could potentially be permitted based upon an
Everywhere
applicant's-
except the BB1.
Okay, but it's only prohibited in BB1.
Yes.
And it is already.
Right.
Well, it is because of the major minor.
Yeah, that's the goal. Okay.
All right,
Sorry about that.
moving on to 7:23. We're 2 hours into the meeting. Let's hope we can finish in an hour because we've said that we have a 3-hour maximum unless we vote otherwise.
We're near the end.
Site visibility triangle. I'd like to have it clear that the site visibility triangle for off-street parking is only in non-residential situations. Because what I don't want to have the site visibility triangle morph into is in a residential property where it's a driveway. But I do want it to be appropriate for commercial properties with the public accessing and egressing their property. Or their
Correct me if I'm wrong, this more is dictated by DOT than anything else, regardless if it's residential or non-residential.
That is
well,
on their road.
somebody can come up and say, I want Jerry to move the bush at the end of his yard because I don't have a site visibility triangle of 30 feet from my driveway.
And so I think what it will say on town streets, roads, etc., within residential districts, the site visibility triangle is not applicable. Right?
Okay, that's what I want.
yeah.
You know, this didn't say it here, so it.
So you're saying it doesn't apply to driveways, it just applies to streets?
It
Is that
applies
what
to
you're telling me?
intersections and it applies to commercial access and egresses from a commercial property where the general public is using it, not
Mhm.
you pulling in and out of your driveway.
Okay.
Okay.
At the very bottom, signs abandoned. Starts at the bottom of the
Can we
page.
go back? Because I'm sorry.
Go.
I get where you're going with this, but right now there are homes that are being built with driveways on fairly major thoroughfares. And
Is there
you
an
know, you put a
example?
bush there on your property.
Is there an example?
And you can't see. I'm more concerned about the guy that's driving down 179 that may be impacted by someone whose driveway prevents them from emerging from their driveway.
When you're coming in and out of your driveway, it's your responsibility to make sure that it's safe before you enter or leave. And the burden is on you, not the person driving down the street. I mean, unless they're speeding.
Right, but this site visibility triangle is going to impede that person's visibility into the street. I can see on roads that are primarily residential, but we've got roads where we're seeing being built along 179, for example, where these driveways come out on 179. That for the person that's emerging from that driveway, if they don't have good visibility because they've chosen to plant something.
Hold on. The difference with that one is that's a DOT road. DOT governs anyway. So this would just be on town-owned roads. But also I want to turn to our town administrator. Nothing is supposed to be planted within the town right away anyway.
That's correct.
So
It
it shouldn't be
All
there
right.
regardless. Am I right? And that's one of the things that we're trying to determine
So-
if we're going to fix or not.
So driveways
That's a
and
huge.
I'm
conversation.
aware. It is, and I'm not going there. But if you're going by something, nothing should be planted in the right of way anyway. We can leave it as is, and it shouldn't matter.
Okay.
All right, let's go on to Ron's, if you're
Yeah.
satisfied. Let's go on to
I'm good.
Ron's.
So sign abandoned, which
because
starts
I've
on
got
the
some
bottom of
comments.
page 723, but then goes over onto the next page. I believe during the meeting, we discussed changing the 30 days to 180 days. It's in the minutes.
I agree.
Sorry, on what page?
It's
Top
actually,
of 724.
it's actually
Okay.
on 724.
Okay, got it. Got it.
And then lower down on that page, on the finish, we used to have, I think, a signed electronic copy definition or something. Maybe that was mentioned, that, and there is no definition anymore.
Don't we
Yeah,
have
I was-
something that's a signed message board or something like that?
I had the same issue. There are what I would call digital, quote unquote, digital signage that are signs that are erected that are essentially video screens that can be altered and changed from a direct source. And I don't see anything in here that A, defines that or gives us some leeway in terms of how those would be managed. I mean, we could just flat out prohibit them if we want, but
Just hold on here.
Hold on. Sign changeable copy, a sign that is designated so that the characters,
No,
letters.
Yeah.
What about
well, that
sign
changeable
marquee?
copy, I mean, that's a
I think
marquee
I know
where you
what
can
they- yeah,
stand
never
out there and
mind.
change the
Yeah,
letters on
never
it.
I wonder if it's supposed to be electronic message center. I've got a note here.
Yeah.
Take a look at
I
it.
thought when we discussed that there was supposed to be something on sign electronic copy or sign electronic message center. I
I
agree.
think it's in the body of the ordinance.
We
might
we
be.
have something already,
Yeah.
because I know we've made people take Walgreens is a perfect example.
Yeah.
Where they had a message board and we gave them 6 months to remove it.
So, yes, we did talk about electronic message center, but that's in Article 3. And that's the reason why it's probably hasn't gotten in here yet, because I haven't gotten to that section yet.
Okay.
Okay.
So when I go back through and revise, there'll be
Add
a
as
couple of
appropriate.
new.
So we're
Okay.
going to add a sign electronic message board.
It's in here to add one, and I just haven't gotten to it yet.
Okay.
Okay.
Thank you, Wes.
Under sign directional, I'd like it to be clearer that this directional sign isn't saying eat at Ruby Tuesdays.
It's
An
not.
arrow. It needs to be what I would term a sign traffic directional. It allows we allow traffic directional signs, but we need to limit the location and quantity.
There is. It's already doing that.
Okay,
It's in Article 3.
3.31.
3-101. It says signs directing and guiding traffic, parking,
Okay, never
exceeding,
mind that.
et
Never
cetera,
mind.
et cetera.
Okay.
Never mind. Okay, add sign electronic. Okay. Signs illegal at the top of page 725. Any sign erected or maintained in violation of a preceding ordinance. Well, I guess because these definitions are at the end of the UDO, we can say that it's a preceding ordinance.
Yeah, but that is a bit strange.
I just did violation of an ordinance.
Yeah.
Take away a preceding and add the word an.
Or this ordinance.
Okay, yes, yes, better.
Okay. All right.
We're not allowing floating devices or flying overhead. I just
Thank God.
didn't know if a floating device was a problem, but I guess somebody could put an Eat It Joe sign in the intercoastal waterway.
Not for the feds, they can't. But sign monument we altered.
Yes, I've got
I agree.
that's
I agree.
in Article 3. I've got that note, but I have not gotten to it
So
yet.
the way I remembered, or my notes say, we have a period after the word ground, and everything right of that, the which measures
Yeah.
stuff was stricken.
I agree, because I don't even understand what 2/3 of the base horizontal length matters.
Yeah, that's again just something that I had not gotten to those revisions yet.
That's the way everybody's got it, right?
Yeah, I do.
Just period
I do.
after the word ground.
So hold on. period after the word ground. Okay. Yeah. All right.
And I have a feeling we deal with this elsewhere, but signs during election periods.
There's political signs. And
Yeah.
I don't
Where
know.
are we?
I think it's the same minutes. Is in the same spot. We were supposed to add a signed political definition
Yeah, we
between
will.
pole and portable.
Yeah, that's on my notes for Article 3.
Yeah, so I think it's all from the same conversation.
Yep. And so, again, I just hadn't gotten to that section yet.
Okay.
Under sign projecting, isn't that really the same as a blade sign, Chad? I'm on page 7-26. If it's projecting from an exterior wall of a building, perpendicular, that is what a blade sign is.
Similar.
I don't see the difference.
A blade sign is oftentimes lower to the ground surface, and it may come out, and it may be.
I think it has to be 8 feet above. Sidewalk.
Yeah, I
It's only one sentence. Leave it.
I would leave it.
Okay. Sign, sidewalk, or sandwich. Is that the same as an A-frame sign?
Yep.
I only saw 3 on my way to today's meeting. That's okay. Do we want to say sign, sidewalk, or sandwich, and then put AKA A-frame sign?
We can add a sentence. Such signs may be referred to as A-frame
Yeah.
signs. All right, guys, we got 15 minutes.
Oh, you have to leave?
No, but just letting you know.
Well, we have until 12 o'clock. We have 45 minutes.
Okay, got it.
I mean, unless you do.
No, it's fine.
Under site plan major, okay, did I jump ahead of anybody?
No,
No,
you're good.
that's
You're agreeing?
the old more.
Go ahead, you carry the ball on this one then.
The 210 was supposed to be stricken, I thought, and said 5 or more dwelling, right?
Yes. The 210 should not be there.
Yeah.
That's what I thought.
It should say
Similar to the other stuff, that's a part of Article 3 changes that I hadn't gotten to. So, but thank you. Yeah, that will be updated.
And a small thing on special events.
I agree.
It says not longer than 2 weeks, but our table allows longer than 2 weeks. So should that be come out of there, or if you look at our table,
Yep.
table 3.2, it does have special events that are longer than 2 weeks.
So that may run in accord with requirements for this ordinance.
Right, something like that.
Okay, I'm moving to page 728.
Yeah. Also, just one thing on special event, we got a double negative in there, but not
We do?
typically,
Where?
not longer.
Special events?
Yeah. In 2 weeks. I know we're dealing with the 2 weeks issue, but just from a grammar viewpoint.
Oh, not typically, not longer than. Yes, okay. Typically not longer than.
But not
weeks.
typically not
It's just-
longer.
Yeah.
just
Yeah.
wording.
Whatever.
Yeah, good.
Fix.
All right, I have nothing on 728 unless somebody else does.
I'm good.
I'm on 729. I see that we do not have a definition for the word structure. And I know we've discussed this. We have a definition for principal structure, but I'm talking about what is a structure.
Wasn't that covered under building?
It says building principle.
Oh, you might be right, yes.
Because it
You
says
might be
build. I
right.
think we now say building structure or something like that.
You-
See,
Under
building
building, we say
principle.
C building. Oh no,
Nope.
no, that's right. Because under building it
Yep.
says C building principle.
And structure.
Yeah,
And
we need
structure.
a definition.
So we need structure.
Okay.
And then right below that, we don't define subdivision anymore.
On its own.
Right. It used to be.
The division of
Well, we define major and minor.
But we don't define what
Or
a subdivision is.
You want to talk about when you're subdividing something, what that means?
It needs to go in here. Yep.
Yeah.
Okay.
Somehow I made a note of that because I read the original definition and it seemed like we still needed it. Subdivision.
Okay. You agree, Chad, Wes?
Yes.
Yeah.
Where did I go to?
All right. I've got nothing until we come to page 731. I've got only 2 sheets left.
I
Wow.
have only one thing on 731.
Go for it.
I believe in the same minutes that Wes is going to refer to, we asked for a definition of tiny home.
Yep. I haven't gotten to those
Yep.
changes yet.
So I think that goes between tent and total.
Yep. And I think it's what we discussed is that it will refer us back to manufactured home.
Under, we're going to move townhouses out to dwelling
Dwelling.
townhouse out in front. But when we talk about a townhouse with well, 0 lot lines, we all understand that. Don't we want in townhomes, dwelling townhouse, townhome, to have a side setback provision for the end units?
I believe it is in there in the use standards. It says that the
You don't have it
Perimeter.
between units.
don't have it between them, but like the parent parcel, you can't have 0
So
lot
it's
line.
covered elsewhere?
Yes.
Okay, I'll buy you that. Okay. The trailer definition, we're really talking about a house. There are 2 types of trailers. There's a house or an office trailer.
No, this one is just a trailer, right?
No, you're right. You're right.
This
This
is
is
not-
something that hauls something else.
Right.
It hauls a boat, or it hauls
Yeah.
a car, or it hauls
Mhm.
equipment.
Mhm.
Okay, never mind. I was thinking of a trailer meaning a manufactured home or a mobile home. All right, tree. And again, we're not here to talk about tree preservation, but we're talking about the definitions. Under tree regulated, we talk about the subsurface roots, and we start right off with it at on page 731. I would be more comfortable if we talk about the critical root zone, because that is well defined within our UDO what a critical root zone is.
Yeah, but
And subsurface roots, we really can't expect people to protect all subsurface roots of a regulated tree. But I want them to protect the critical root zone of that tree.
okay.
Does everybody see where I'm going with that?
Mhm.
Yeah.
We don't have a definition for canopy or understory tree.
We don't need that anymore because we've
But we still have tables for them.
but yeah, I can add those here. They're defined in that text. Sorry, let me.
In the section, right?
Yeah, and I went to see that, but to me it didn't define the use of a canopy. Now I know that a canopy, or at least I think a canopy tree goes along a streetscape, and an understory tree is something that's going underneath another tree.
We can add those definitions. The understory trees at the time of planting, the tree shall have a minimum 2-inch DBH, et cetera, et cetera.
When would a tree be considered an understory tree?
We are only your consideration of these is really only for planting species when you have to go back and plant either an understory or a canopy or a shrub, and then it's defined in these various categories.
Right, so you're saying you're not going to add a definition.
I can
to this.
add the definition that's in the text, which is fine. It's not a regulated tree is regulated, and then if you remove trees and have to plant them back, then there's certain categories of what you have to plant back.
Well, I'm not saying it should be under regulated tree. I'm saying it should be under the definition of tree.
We can add
Or near.
tree understory and tree canopy.
Okay. All right, moving on to page 7-32.
I want to talk about heritage trees for a second.
Before we get to that,
Oh, sorry.
can we go to the one that's the regulated tree? It's at the top of page 7-32. And we talk about live oaks.
Is that what we had from our
Not
list?
being a tree person, what is the difference between live oak, pin oak, and water oak?
Well,
And red oak.
they're just a different varietal.
Do
of
we
an
have
oak
all
tree.
three of them
But
here?
live
Yeah.
oak is certainly more of what we all would refer to as a heritage tree before. It's
Yeah. My concern is there's a lot of confusion between the difference between a live oak, a pin oak, and a red oak. I thought
and a water oak, which I have
Water
a
oak.
ton of them on my property.
And so I think we may think we've included protection for a wider variety of oaks than is actually included in here.
So you're protecting a live oak that's 4 inches. You're protecting any other oak that's 18 inches.
Yes, and
So
that's why I'd like number 2 on this. And when it says any other tree species 18 inches, I think it should be a tree listed on table 3.5 or 3.6. I don't think it's our intent to protect a 19-inch pine tree.
I think we had this discussion, and the discussion was that you guys wanted to leave pine trees in there, and we went all through it. But because I believe the original definition excluded pine trees.
Oh, yes.
No,
I'm
Yeah.
for that, but
I thought we took out the pine,
Mm-mm.
other than the long, we discussed
Yeah, we
there's a
kept the
difference.
longleaf pine, and that is
Yeah.
in the listed.
We took the
yeah, the
loblolly.
long leaf is
It's
listed.
not in there anymore.
Longleaf?
Yeah, it's here.
I think it is.
I'm trying to
It's right
find,
under tree
where's the
heritage.
table, where's the section?
Oh, okay.
Tree
got
what?
it. Okay, yeah, it's under heritage tree. Yeah.
Well, also, as we're mixing this up here under number 1 there, where we talk about live oaks and dogwoods, and we say other ornamental flowering trees, I do not think it's in our best interest to be protecting Bradford pears.
Well, that's
an
not really a tree.
But that's an ornamental flowering tree.
So we can take that out.
Well, I would just
Oh.
say excluding Bradford pears.
Wait a second, what section is that section in? Can you refresh my memory?
Uh,
It's Article 3.
What section?
I don't know that we have the bandwidth to get into trees.
No, but I think we had really addressed some of this stuff already. And
well,
it's-
hold it. How about it? Because this is pretty complex.
And
How
we're
about
going to
if
talk
we-
about it again.
Let's look at it when we go back on our phase 3.
Yeah.
I'm going to make a margin note here
Yeah.
to look at these things when we look, because then we can still, we still have the opportunity to redo these definitions.
Well, I think some of it's already been done, I think,
Yeah.
on the list. All right. Because, all right,
Everybody cold.
it just went on, I felt it. Canopy trees, we've taken out the loblolly pine. And table 3.5. So I think we just got to make sure our definition agrees with what's in the list of the heritage tree and the regulated tree, because
Yeah, right now I don't see them as being
it-
consistent.
I think, yeah, we just got to make sure that that's the same.
Yeah.
Because we've done some of this in the section of trees that maybe doesn't quite agree anymore with the definition. So I'll end it
You
there. I
can't
guess.
keep redoing and redoing and redoing.
Yeah, but this is an area that's pretty important. I mean, what I hear from residents is how upset they are at the variety of trees that are being cut down in
All right,
the
let's,
developments
that's
that are
not,
being
that's,
added.
let's go back and look at, we're going to be looking at the tree section anyway.
Okay.
Let's go back and
You-
look
you-
at it
you'll-
at that appropriate
Ho-
time.
Hopefully next week you'll get all of the remaining updated articles, and if I can, I'm going to try to update the definitions too, based on today's meeting.
Okay.
We'll note that under heritage trees, they can be removed with a variance from the Board of Adjustment.
hmm
And I'm going to keep that in mind when I'm looking at this 32-inch, because I'd like to do something even 2024.
And
But
going to what
but
Pete
that's there.
said, should we have a line in this, in the 325 section that specifically says no Bradford pears? And just,
Well, it's the only one I can think of that is so predominant. I mean,
Or just get rid of the broad thing and just call out those species that are
Well,
4 inches.
I like the broad protection of ornamental.
oh, I'm not saying remove it. I'm
Yeah.
just saying it.
I thought that's what
it
you're
would-
being
it would-
suggested.
yeah, but
No,
say,
Well,
no.
I
Other-
think let's just talk when we get to it.
Okay,
next
I'm going
time.
to put a check mark there.
Okay.
Under utility service small on page 732, we have well, comma, water. It's well water. It's one thought. There's not a comma there.
Boosted devices and well water?
It's saying that it's a well, water, and wastewater pump stations.
Well,
Yeah, it's okay.
I don't think it reads right.
Because you can have a water pump station and a well pump station.
Mm-hmm. Yeah.
Okay.
Okay, I don't know. Well, I guess I do have it on my irrigation system. I've got a water pump. Okay, all right, I'll take that back. This is the last page on 733. My goodness. Under wild animals, I think we need a definition for yard sale. We have flea market that's referenced
What here?
in our book. Well, I'm saying I'm giving you a placeholder for it, but we need to have
why?
a definition for yard sale.
Yeah. We're not adding
Oh,
yard sale to
yeah,
the
wild
Yeah.
animals.
No,
We're
no, I'm
adding-
sorry.
Yeah.
Okay.
And then for format, Wes,
Mhm.
previously we used to have like a subheading with the letter and then the section and space. For future adds and subtraction, the way we are now, if we have to insert one the way it's format, are you going to alter the format a bit to allow open spaces? The previous way we had the letter and then we had the things under the letter and then a gap and then the letter.
They'll have the Word document, so they'll just go in and plop in the
Because if we have to add or change the definition later and it gets too big, it pushes all the pages.
well that's
You know what I'm saying?
well that's just how it'll work.
Yeah. There's no other way to do like each letter by a Y page and a page.
No,
and
like
B-
for example, if we were to amend Article 7 like this, it would be amend Article 7,
You would just push everything back.
7.3.
Yeah.
yeah, but it doesn't. If things get pushed to page and every page after that has to be reprinted.
Yeah, but that's
That's just how it
it's
is.
just how it is. Yeah.
Yeah.
And it's possible this will go into Municode. I don't know.
Okay. And the only other questions I had, Chairman, was I think we talked about things, definitions that have kind of disappeared. We talked about the garage private is not needed. There used to be one for joint access driveways. There used to be one for recreational vehicles, parentheses RVs. And we talked about the subdivision. So those other ones have been removed because we've determined they're not needed. Or is
Let
this
me
oversight?
double check on the recreational vehicles. What was the other one you mentioned?
Well, garage private we talked about. Joint access driveway.
I need to double check and see if
I just noticed that they're missing. Were they just missing because we decided we don't need it, or it's an
Sure.
oversight?
the recreational vehicles. That definition is also in flood damage prevention ordinance. But let me double check and make sure that we don't need to put it back in. Thank you for pointing that out. Joint access driveway. I can't recall, that might have been taken out because
It seems like it was two residents using the same driveway.
that's right, and I don't believe that's something that you require. In other words, wouldn't need to be in there.
I could be had either way. Just
Okay,
I'm just noting it as
Okay.
missing. So missing. It's an MIA.
thank you. And I do apologize that there's a number of these changes that weren't incorporated yet. I was trying to get this section to
Hey,
you.
getting this to us when you did was huge.
Yeah,
Yes.
it really was.
Otherwise, we would not be talking about this today.
Okay.
So it's
Here's Article 1 and 2 revised. And so and I guess we'll get to the next agenda item, but
Thank
Are
you,
we
Chad.
getting new binders to start filling?
Go buy
No.
your own.
Go buy my
Go
own.
with your salary. That's why you get paid, so you can buy your own binder.
it might not be a bad idea, like Ron
you
suggested,
said
find a
that
binder at the
Sunday.
house and put the new
About how
material
long
in the, and so
I
you
already
can
have
keep them
this one
both.
up to now.
Yeah.
What'd you say about
And I
that?
vote for a new picture on the cover
Yeah.
of our new UDO, but you probably aren't influencing that.
Okay.
This-
What pic? Should we put a picture of your fine mugs
Yeah.
on there?
The happy planning board.
Yeah.
That's right.
We avoided the picture entirely.
Call them if there's a question.
There you go.
All right, seeing how we've finished with definitions, is the board satisfied with where we are? That that's where we are in the agenda right now?
I think this was a very productive set.
Well, the next item is public comments, and we're still going to have, Chad is still going to talk to us about some scheduling things.
Yeah, this went before public comments though.
Okay,
So upcoming articles and meetings.
I put it in the wrong spot.
Okay.
Yeah.
Yeah, upcoming articles and meetings. So you have your first two articles. You will have your next deliverable from Wes next week. We will, there's a conflict with Wes on the June 15th
Okay,
meeting. So we are moving the UDO meeting from the 15th to the 1st.
okay.
So we will meet on the 1st. It probably will just be, potentially just be for
UDO.
the UDO.
And that means that this that you've just given us?
Will be what we talk about.
Plus, we're going to have some stuff on the 25th when we see him next here. He's
Yes.
going to hand us
I hope to.
maybe
Yes.
a
My
section
goal.
of
My goal is.
3 or 4. Or,
Yes. Yes,
Three
sir.
is a big one.
yeah.
I know. I've started working through it. So.
So all the
So
other
June
meetings,
1st will be UDO update.
Yes.
So
Yes.
that really only gives us a week from the 25th when he hands us more stuff.
Well, remember, technically, let's say that something happens between now and then. I'm not able to give you new material. You have those articles
Our-
for
our-
us to review June
Our
1.
problem right now is we have something else on the 25th
Yes, that's
that we're going to be working night and day on. I'll read this.
Yep.
Maybe.
Okay, so
Yes.
here, Mr. Chair, that's a good point. I mean, do we just need to not try to hold that
I
and
hope
try to
Lisa's
put?
not listening.
Well, the June 1, should we try to meet later in June to give you guys enough time, or just skip June altogether and come back in July? And in between now and June 1st, I can try to get you guys a final copy so you got it all together. Given that, because I forgot about that you guys are going to be preoccupied. And I'm not trying to.
just
No,
to
I
let
know.
you know, the 19th through the 23rd, I will be in a floodplain administration class at Morganton.
Is that in June or July?
That's in June.
I'm
So
gone
moving
the
it back
last 2
from
weeks
the
of June.
15th back
Yeah,
a week
he-
to the
yeah.
22nd would
Ron
be
had already told
problematic.
us
For the
he's
whole
gone.
week? Did you say the whole
Yeah.
week?
Yeah.
So we could meet. What I was saying is that we could possibly meet July 6th to sort of be dedicated to the UDO, or July 20th. I would think that there'd be ample time because it's possible that the other item could be into mid-June. I don't know.
So, right.
Or longer.
So in other words, push the next UDO update to July 6th.
Or the 20th.
And we'll have more text by that. We'll have the whole text by that time. And hold the June 1 meeting as an additional CZ meeting.
Not
Well,
potentially. That's
yeah.
not. That's to be determined.
That's yeah.
Well,
But,
again-
but don't try to meet on June 1st about the UDO. That's the key. Sounds like that's probably the advisable.
And I'd like to have that date as a potential for the
Other item.
application we have in front of us right now.
Okay.
Well,
Is that a doable date?
I don't think so. That's why I was moving the 15th UDO meeting up from the 15th to the 1st, because I don't have anything else on that meeting date.
On the 1st.
That's correct.
Okay.
Well, but we're not going to be done with this.
I'm aware. We'll deal with the conditional zoning stuff as it comes on, and I will have more definitive direction to you on scheduling dates after the 26th during that meeting. But for the 1st, it will not be
Well-
contained with conditional zoning.
We had a bit of a kerfuffle while you were gone
Yes.
on advance notice of this.
Yep.
My suggestion is we block out dates
Yep.
for us
Yes,
that are potential dates
yes,
so that we don't do something else on those dates.
that's fine.
So
I don't have that information for you to block out dates yet.
why don't we do this? Let's stick with, why don't we stick with June 1st as a potential UDO meeting? The Article 1 and 2, there was not a ton of changes. And I think it's possible that
Well, we'll only get through what we get through.
and we'll only get through what we get through. And at that point in time, we will all be here then. And if there needs to be an agenda item on there for scheduling future meetings about this and the other item, it could be discussed then.
And the 15th, you are not available.
I don't believe so.
Okay. 15th
Well,
of June.
Yes, sir.
We're not.
As I said to you earlier, I don't think the 25th and
If we move this
26th
to
gets
the
us
first,
any
then
nearer
we'll-
to the end of that thing.
Oh, not even
And we
close.
need multiple more days blocked out.
I don't.
Or expect to have what happened at the last meeting to happen again.
I don't disagree with you. I do not have that information to be able to block out dates yet.
Well,
So let's point aside June 1st as a date upon which
Which is our regular meeting.
we will
Yes.
set up additional meetings for the conditional rezoning applications and
needed.
additional meetings.
I'm waiting on one person to respond to me who.
But
is
you'll
on it.
know that by the 1st of June.
I'll know it by next Friday.
Okay.
But and trust me, I've watched the meeting. I will take into consideration everything. I'm waiting on one person to reply who's on vacation, their availability. So once I have that information, I will be able to send out emails to you to block out dates for future
Okay.
meetings.
All right, and we do have a meeting on the 1st of June. We
Yes.
have a meeting on the 25th, we have a meeting on the 26th.
Yes.
Those discussions can take place
Yes.
at least off record
Yes.
there as well. So,
Yeah, and thanks for raising that because I know.
I don't,
Go ahead.
I don't, I wasn't making myself clear. I'm saying we as a just five, to block ourselves out on dates. If they turn out to be impossible, then we unblock them, so we don't come up with the same point as that.
So you're saying you want to provide blackout dates?
I'll make a statement to you, I'm available anytime in June, because the things I have, I can change.
I can't do, yeah.
Now, I
Well,
know
in other
you're
words, what I'm
gone,
saying is
you're gone in June
we
for a
know,
couple of
no,
weeks.
at the back end. We already know June 1st. We've blocked out a date because we have a regular meeting.
Yes,
But I'm saying, wouldn't it be wise for us to block out, for us five only, I can't commit anybody else, or we can't, some additional dates like the 8th or the 2nd or the 9th
yes, yes,
to
yes,
say,
yes.
for us, let's not, that we're making ourselves available that date until told it's not possible, and then we unblock it.
But what we
So-
block, excuse me,
Go
Go
ahead.
ahead.
what we block out now might not be what he finds out we can block out, and we,
Well, but Ron brings up a good point, and it's
Yeah.
not to cut you off, but he just told us that he's gone the last half of June. So now we at least know that. Well, I also know that Richard is out until the 31st of May.
Let me ask you this. Would it be just wise for each of you individually to text me dates in June that will not work for you?
That will not work.
Yes.
Is that,
Yeah.
that can work.
how about June and July?
June and July, do it.
Yeah.
Well, no, just June
For now.
for now.
Okay.
Let me know, but send it to me today or by the end of the day tomorrow.
Mhm.
Dates that will not work for you in June, and I will take all that.
I'm not going to send you anything because I'm available.
Just send me an email and
Me
say
as
you're
well.
available.
I will make myself available.
Yes,
Okay.
So
I
send
think,
you
I think
dates.
I will too.
yes.
Send you dates that were not available in June. That's fine.
Now, my only caveat on June
and
1st
July.
is
No, but
Just you.
just June.
I may not be able to get here by 9 o'clock. So if that's okay, you guys can start.
I can promise you the only thing that's on the June 1st agenda will be
It's
your
going to be,
Article 1 and 2.
which I'm fine with.
Okay.
If I get
If
here
you're
by
late,
10,
you're late. Well, as long as we have a quorum, we can start.
Yeah. So but I just wanted to make the board aware of that, and then we'll send you avails for June, or
Yes.
not
God,
avails,
congratulations.
and then That's what we'll do.
Yep.
Okay.
Okay.
Have we satisfied that
Yep.
agenda item?
And
And
just for the record, we're not canceling the meeting on the 1st.
right,
We'll
we're
be
not.
here.
And I would like us not to cancel the meeting
We'll
on
get to
the
that. We'll
15th
get to
either.
that when we get there.
I would like not to cancel the meeting on the 15th.
That's- Yet. We
Yeah.
don't have to.
Right.
Okay,
Correct.
Wes may be available. That's, who knows? Or we could maybe use that for the other, well, no,
Yep.
we can't because we need you
Yeah,
for that.
staff will, again, we'll go.
All right.
we'll-
Now
Other
we're coming down to
comments?
public comments, if that's okay with everybody.
Sure.
And seeing we have somebody in the audience, sir.
Been very patient. Thank you.
Yes,
Very
thank you.
patient.
Thank you for your
3 minutes, give your name and address, please.
Todd Wilson, 424 Lakeshore Drive. I came today to speak, and I was happy to hear y'all have a brief discussion when it came to the architectural standards and things like that within the town. Lakeshore Drive, there are a couple areas that have a unique situation where a block of the lots on Lakeshore Drive are in Sea Trail, where the other side of the street
Yeah.
is just Sunset Beach. So you have different architectural standards that are required from one side of the street to the other. Currently, there is a house being built across the street from me, which is Sunset Beach. The quick particulars, it is a 3-bedroom house with an 8-car garage.
Whoa.
Now, the living,
We can't respond.
oh, I know,
back to
the
you, sir.
living square footage I associate with a 3-bedroom Sugar Sands home. About the same square footage with an 8-car garage on it. Okay. Now, you talked about nature of the community, atmosphere of the community. I challenge anyone to ride down my street and take a look at this house and see what you think when you first see it. It totally changes the nature of the community. I can't even start to talk about the roof line. You talked about disparities earlier. There is easily a 10-foot difference in the roof line of existing homes right next door and this home. Literally, when I go up on the second floor of my house, the other day, went up, stood on the couch, looked out the window. I cannot see over the roof of this single-story house. It is so high and so far extended. Then there's a lot of little things. I really do feel it affects the nature of the community as well when you look at this home being built and the home directly next to it. This home sits entirely in front of the home next door. The home on the lot next door starts about 15 feet behind where this house stops. There is such a disparity that could literally break up that lot and sell the front to someone else to build a house on. There is such a big disparity. So I was glad to hear that you guys are going to look into these things. I feel that this is something that needs to be looked into more about the community, how it affects the community and the existing homes that are there when you're going to be having a new home put in. There was another one that is almost finished just down the road from me. It is a 2-story home, but it does not have the same effect because it is set back off the road much farther. Even though this home meets the setback requirement, and it is the same as the one next door, the height and how this home is constructed really changes the look of the neighborhood. Thank you.
Thank you.
By the way, I live on your street.
Yeah.
Yeah. And what was your address again?
424 Lakeshore Drive.
Thanks.
All right, thank you. Seeing there's no more public comments, I'd like to entertain a motion to adjourn our meeting.
So moved.
All in favor?
Aye.
Aye.
Aye. Thanks, everybody.